Good afternoon, Your Honor. My name is Matthew Barrett. I'll be representing the defense and opposing plaintiffs in today's case. I'm joined by my co-counsel, Patrick Callahan.
Good afternoon, Your Honor.
And Patrick Duke.
Good afternoon, Your Honor.
Duke, is it?
Dugan.
Dugan.
Yes.
Okay. All right, the court will briefly remind the parties of the procedure for argument, even though I'm sure you're familiar with it. Parties will each have a total of 8 minutes to present argument, with the possibility of up to an additional 2 minutes in courtesy time that the court may permit at its discretion. Counsel will each have 45 seconds to present your argument without interruption, after which the court may ask questions. Counsel for Carbo will argue first as the moving party. The jury is constructively absent for this argument, so counsel should address the court. Okay, counsel for Carbo.
Yes, Your Honor. Before I begin, may I reserve 3 minutes for rebuttal?
You may. Thank you. Timekeeper for Carbo, are you present, ready to proceed?
Yes, Your Honor.
Timekeeper for Shooting Star, are you present and ready to proceed?
Yes, Your Honor.
All right, when the first 45 seconds expires after each side's argument, both of you please stand quietly and prominently display your time cards. Do not call time aloud unless I do not see and acknowledge you. When time expires for the main argument, please stand and say out loud, stop. You understand and agree to abide by these rules?
Yes, Your Honor.
Yes, Your Honor.
Good. I may permit courtesy time for each side up to 2 minutes per argument. Immediately upon the expiration of any courtesy time, you are required to stand and call out time. Do you understand and agree to this rule?
Yes, Your Honor.
Yes, Your Honor.
Very good. Counsel for Carbo, as you've already done, you may reserve up to 3 minutes of time for rebuttal argument, and you've already reserved those 3 minutes. Okay, counsel for Carbo, you've reserved 3 minutes for your rebuttal. Timekeepers, please stand and notify the court after 5 minutes, leaving 3 minutes for counsel's rebuttal. Okay. All right, counsel for Carbo, you may proceed.
Yes, Your Honor. Good morning. Cy Turner for the plaintiff, Ms. Justice Harper. May it please the court. The question before this court is whether Section 2007 of the Imperial Civil Code, which creates civil liability for the reckless entrustment of a firearm to an unfit person, violates the Second Amendment. It does not. My client, Ms. Justice Carbo, was severely injured at the defendant's shooting range by an employee entrusted with a gun. And our second cause of action in today's case arises under the Imperial statute. This court should grant the plaintiff's motion in limine and allow Ms. Carbo's statutory claims for reckless entrustment to proceed to trial for 2 reasons. First is that the Second Amendment does not apply to the Imperial statute because it does not affect the right to keep and bear arms. And second is that even if the Second Amendment does apply to this statute, the Imperial statute is constitutional because it is consistent with historical restrictions on gun use.
Counsel, do you claim that none of the fitness factors in the statute offend the Second Amendment, or do you claim that some of them do, but that they're not all at issue?
Your Honor, none of them that are present in the Imperial statute offend the Second Amendment, as they are all consistent with historical restrictions on gun use. Furthermore, the Second Amendment applies to none of them. The defendant has raised an as-applied challenge to our application of the Imperial statute, which means that they have challenged our application of the statute to their Second Amendment rights.
Well, how does a federal firearms dealer, an FFL, if you will, determine whether a prospective gun buyer is unfit in the words of the statute?
Well, the statute lays out several criteria that determine somebody is unfit, and all of them are in line with other historical analysts. Things like age, maturity, intelligence, a general trait of character as a cautious or safe person. These are all character traits that were upheld as reasonable and constitutional by the court in Bruin.
Isn't that kind of subjective, though, on the part of the FFL dealer, the firearms dealer?
Your Honor, yes, it might appear subjective, but first, there is no objectivity requirement for laws that impose conditions on commercial sale of firearms. The only document that supports an objectivity requirement is a concurring opinion in Bruin by Justice Kavanaugh, but not precedential case law or the majority opinion in that case. And two, the court ruled that the Connecticut statute, which imposes restrictions on those whose conduct shows that they lack the essential character of temperament necessary to own a firearm, the court already ruled that that was objective enough to meet the requirement.
I'm sure it is, but who decides whether their temperament is appropriate to buy a federal firearm, to buy a firearm?
In the case of the Empyrean statute, it would be business owners, i.e. gun sellers, who determine the general trait of cautiousness and all the other character traits that are listed in the Empyrean statute.
So they're basically being judged by the same standards that that Shooting Star is going to be judged by. I mean, isn't it kind of? My concern isn't just the Second Amendment, but isn't it unconstitutionally vague or overbroad as well?
Well, Your Honor, the defendant's challenge is only to the Second Amendment and our application of this statute to their Second Amendment rights. There's no motion that's being heard today as to the vagueness of the statute, but also note, Your Honor, respectfully, it is similarly vague as other statutes that the court has already ruled are constitutional. To take again the Connecticut statute, which lays out that people who lack the essential trait of temperament are not allowed to purchase a firearm. Now, temperament is a broad discretionary category that federal and state regulators would apply up to their discretion. That's very analogous and very similar to the criteria laid out in the Empyrean statute. The fact that they are discretionary and the fact that they are applied by a body or person who gets to choose whether or not somebody is fit, they're all analogous situations.
Couldn't the federal firearms dealer violate the Second Amendment, him or herself, simply by denying a permit just because they felt that the temperament of the prospective buyer was not appropriate?
I'm sorry, Your Honor, are you asking the context of the Empyrean statute or another?
The Empyrean statute.
Well, the Empyrean statute does not require the issuance of a license by a federal licensing agency. It only requires the assessment of those character traits by business owners, which means that there's no licensing issue to speak of.
But they're deciding whether to sell them a gun or not, aren't they?
Yes, Your Honor, and business owners have discretion on whether or not to sell somebody a firearm, which is not an infringement of their Second Amendment rights. For these reasons, Your Honor, we respectfully request statement grant.
Thank you. All right, counsel for Shooting Star.
Yes, Your Honor.
You may argue.
The defense opposes plaintiff's motion in limine and seeks a ruling that the statute underlying plaintiff's second cause of action violates the Second Amendment. This is a case in which plaintiff is suing Shooting Star Gun Club for negligent hiring and retainment of Drew Cantrell. This argument centers around Empyrean's Responsible Firearm Sales Practices Act, which violates the Constitution based on one, the plain face of its text, and two, plaintiff's failure to find appropriate historical analog. Section 2007 prohibits the reckless sale or entrustment of firearms to any individual, quote, unfit to use that firearm. New York State Rifle and Pistol Association v. Bruin establishes a multi-level analysis by which we can determine the constitutionality of the statute. The analysis being one, whether or not the statute contradicts the plain text of the Second Amendment, and two, if it does, whether or not there are historical analogs to the statute. We submit that the defendant that Shooting Star's conduct is protected in today's case, and that plaintiff has failed to meet their historical burden.
Well, let's talk about the plain text of the Second Amendment. Let's analyze that a little bit. So the Second Amendment is basically composed of two clauses, the militia clause and the right to bear arms clause, right?
Yes, Your Honor.
Sometimes called the prefatory clause and the operative clause in some parlance, right?
That's correct, Your Honor.
All right. So how can the prefatory clause, in other words, the reason for the rule, trump the rule itself? In other words, the right of the people to bear arms shall not be infringed. How can the militia clause trump that, the right to bear arms clause?
Well, Your Honor, the Supreme Court found in Heller that militia was essentially an individual right. That at the time it was written, militia meant individual American citizens. While regulated, on the other hand, was essentially synonymous to well-trained. Now, specifically, as it's applied in this case, Supreme Court found that to confine the word bear, as used in the Second Amendment, to the home, would essentially nullify the Second Amendment. because the Second Amendment protects individual right to publicly carry firearms. Well, Your Honor, in the same case, what Section 2007 does is it essentially renders the Second Amendment null and void. Because what it does, by restricting sellers of firearms to the point where they are not able to freely sell firearms to individuals, that inherently restricts the individual right to acquire firearms. Specifically, a plaintiff talked a little bit about how this is an as-applied challenge to Mr. Cantrell. And that is all that is true. However, plaintiff is also bringing a cause of action today, which involves Justice Carbo's fitness to own a firearm. Now, Mr. Carbo, on the grounds that he had no familiarity, no experience with firearms, under Section 2007, he would apparently have been restricted the ability to have a firearm, the ability to be sold a firearm on the grounds that he lacked training.
Right, but it's not restricting his ability to buy firearms, period. It's restricting it under some conditions. In other words, it's like a well-regulated restriction, isn't it?
Oh, Your Honor, that's correct, but we can't mortgage an institutional right on a string of maybes. What matters here is the transaction at issue. This is how Justice Carbo was being would have been prohibited of having a firearm. And then the question was, well, he could not have been entrusted a firearm either in order to learn how to use it, because under this law, one cannot be entrusted a firearm. So then the question becomes, how exactly is Mr. Carbo supposed to gain experience with firearms without being able to use one, to train with? And it's for this reason, Your Honor.
Borrow someone else's, couldn't he?
I'm sorry, Your Honor.
Could borrow someone else's firearm, couldn't he? Train him?
Again, Your Honor, but the question is not whether or not he could have gone a different route. The question involves the transaction at issue between Shooting Star Gun Club and Justice Carbo. And Your Honor, plaintiff said that there is no motion as to the vagueness. This is a motion as to the vagueness of the statute. However, that is exactly the problem. The problem is the vagueness of Section 2007.
I just asked your opposing counsel about vagueness. You said that doesn't enter into a Second Amendment challenge. Does it? Do you disagree with him?
Well, Your Honor, I do disagree because Section 2007 is not narrowly tailored to serve a government interest. What Section 2007 does is it gives gun retailers a list of factors by which they can determine the fitness of someone to have a firearm. Now, take some of these factors with plaintiff work, such as age, maturity, intelligence, good character. If we take intelligence, for example, if intelligence included an IQ test, insofar as an IQ test is objective without addressing civil rights concerns or threshold for a proper score, that would be permissible. However, Section 2007 makes no mention of an IQ test under this prong of intelligence.
Well, let's forget about IQ for a second. Let's just talk about mental competency. I mean, you would certainly not suggest that mentally ill should be allowed to have guns. Are you suggesting that, or aren't you?
Oh, well, no, Your Honor, I'm not. And the Supreme Court has found that there have been restrictions on the use of firearms by the mentally ill. But the problem is, Your Honor, Section 2007 does not define what constitutes mentally ill. In fact, one of the things it says, one of the factors is good character. So
what if the mentally ill person, what if the prospective buyer of the firearm had just been institutionalized once or twice earlier that year, like a Lewiston shooter, and wanted to buy a gun, then what?
Oh, see, Your Honor, that's exactly the point. We don't. What one gun retailer may look at that history up and say, yes, this person is unfit. Another gun retailer may look at that history which you outlined and determine that that does not constitute an appropriate threshold by which they can be determined as unfit. And Your Honor, objectivity is necessary. The Supreme Court made this point clear in their distinction in Bruin between may issue and shall issue regimes. Shall issue licensing regimes these were two different regimes by which one could have a license to carry a firearm publicly. Shall issue regimes employed an objective criteria. However, these may issue regimes often left discretion up to the licensing official. And to quote Justice Kavanaugh in his concurring opinion in Bruin, New York's outlier may issue regime is constitutionally problematic.
That concurrence, that wasn't necessary to form the majority in Bruin, was it? I mean, in other words, Justice Kavanaugh's concurrence isn't controlling in Bruin, right? Because they had enough votes to strike down the New York State law in Bruin without Justice Kavanaugh's concurrence, did they not?
As Your Honor knows, the concurrence, correct, is not the law. However, the concurrence is reflective of the majority opinion. And Your Honor, what this ultimately boils down to is this. Section 2007, what Section 2007 does is it turns an constitutional right into a burden by enjoining a special responsibility on gun retailers to determine what exactly fitness to have a firearm constitutes. And it's because of the fact that the plain text of the Constitution protects the shooting star's conduct in this case, and that the plaintiff has failed to find appropriate historical analogs, that we ask for a ruling that Section 2007 violates the Second Amendment as applied in this case.
I'm going to give you a little more courtesy.
Okay.
I think I can do that more courtesy. I mean, but the federal firearm dealer, him or herself, has undergone some licensure requirements just to be able to sell guns. Has he or she not?
They may have, Your Honor, in terms of the commercial sale of firearms, but the problem is this law is too broad. And what essentially it does is it puts this tremendous responsibility on just an average person who may not have any particular training in the use of
An
the
average
advocate.
person with a federal firearm license?
Oh, but Your Honor, what this law is doing, well, that would be in terms of the May issue regimes. However, May issue regimes and Section 2007 are similar because both involve the government putting a responsibility on an individual to determine whether or not someone has a fitness to have a firearm. Section 2007 puts that responsibility on a gun retailer, an average person, to essentially decide how the law applies in that case. And Your Honors, for this reason, we ask that the court to rule that Section 2007 violates the Second. Thank you.
Rebuttal?
Yes, Your Honor.
3 minutes.
What Your Honor can be sure of is that the Imperium statute is constitutional. It passes the two-part test put forth by the court in Bruin. It does not, one, obviously violate the plain text of the Second Amendment, and it does, two, have a historical analog for the restrictions contained within it. I'd like to draw the court's attention once again to the Connecticut statute, which prevents people whose conduct has shown them to be lacking the essential character of temperament necessary to be entrusted with a weapon from buying a firearm. Your Honor, this is just as broad, it is just as subjective, and just as discretionary a criterion as any single criterion within the Imperium statute. Now, second, Your Honor, is that there is no objectivity requirement put forth by the court in Bruin. Your Honor was exactly right. Justice Kavanaugh's concurring is not controlling or binding precedential case law. The reason why it was not included in the majority opinion is exactly because it is not exactly reflective of the majority opinion. But even if Justice Kavanaugh would have voted the same way as the majority, he included things in his concurring opinion that were not included in the majority. This is because concurring opinions not define the scope of the application of the majority opinion within a Supreme Court decision.
But a federal firearm licensee isn't just a person on the street. They're just not a store clerk or anything like that. Presumably, they've had to undergo some kind of screening to get that federal firearms license. I mean, why couldn't they be trained to spot somebody who's unfit to purchase a firearm?
Your Honor, they very well might be, but so might business owners. So most business owners who sell guns have licenses to do so and are presumably experts in their field. But furthermore, Your Honor, the court set forth no criteria by which to judge the application of the standards given under a statute.
Why couldn't we use Justice Stewart's definition that you know when you see it? Justice Stewart's definition of obscenity, that he knows it when he sees it. I mean, if you know somebody who's unfit, you're not going to sell them a license. Maybe it's just common sense analysis.
Absolutely, Your Honor. I agree. It is a common sense analysis, which is exactly why business owners are able to do it so easily. That's exactly why a business owner is in no fundamentally different position to assess the character of gun applicants than the federal or state license issuers are. It's because it is a common sense, know it when you see it test for traits that are historically analogous to laws that have already been ruled constitutional. For these reasons, Your Honor, the plaintiff respectfully requests that you grant our motion to eliminate and allow Justice Harbo's statutory claim to rest.
Thank you, counsel. We're going to take a few minutes to deliberate this. The court appreciates your hard work in briefing and arguing this issue and bringing it to the last television. During that time, please remain in the room. Remember, you may speak only to students on your team who are participating in this particular trial. Timekeepers, please start the clock and announce when 3 minutes has passed.
Your Honor, 3 minutes has passed.
3 minutes has passed. All right, the court thanks counsel for their argument is ready to roll. Based on the argument presented today, the court grants the plaintiff's motion and eliminates. Accordingly, the court finds that the 20 Imperial Civil Code Section 2007, the Responsible Firearm Sales Practices Act, as applied in this case, is constitutional under the Second Amendment. Did I get that right? Is constitutional under the Second Amendment.
Yes, Your Honor.
That would be consistent with granting your motion, right?
Yes, Your Honor.
Thank you. I just wanted to make sure I know that. You know, it's the trial court's job not to express agreement or disagreement with the ruling of a higher court, like in this case, the U.S. Supreme Court in the Bruin case, which I think it's safe to say went further than Heller and McDonald went. It's just the trial court's job to apply the law and not to agree or disagree with the holding in Bruin. And I think that you already persuaded the counsel that this statute is consistent with the Supreme Court's holding in Bruin. The court accordingly, I'm going to grant your motion to limit. All right. Since the court has granted the motion, Justice Carbo's second cause of action will proceed at trial. Additionally, exhibits 16, 17, and 18 may be offered to evidence by either party, subject to the Empyrean evidence ordinance. This concludes the pretrial argument. The court is ready to move to trial. We are now ready to begin this trial. I'll give the parties an opportunity to handle some brief housekeeping matters. I'll start with counsel for Justice Carbo. Counsel, do you have any housekeeping matters to discuss?
Yes, Your Honor. First, we ask Your Honor's preference about asking permission before approaching opposing counsel, the witness, the jury box.
Yeah, I would actually prefer you not to ask the court permission to do that. I think that's unduly formal, and I think you should feel free to use the well of the courtroom as you would a theater to just approach or not approach and just hand counsel without asking the court permission. I prefer a more informal approach in that regard. Anything else?
Yes, Your Honor. Given that, I'm approaching opposing counsel with a copy of what has been marked as Exhibit 21. And I'd like to draw the court's attention to precedential case law in this case, specifically Satan versus Patron. This case states that character evidence is an integral and essential element in a negligent hiring or retention case. We must prove that Drew Cantrell had some character trait that Shooting Star recklessly and negligently ignored. In order for us to meet that burden, we must be able to establish what that character trait is. And Satan versus Patron says that we are allowed to do so through Rule 405B, as specific instances of conduct. With that being said, Your Honor, the plaintiff offers Exhibit 21 in the evidence, which is Drew Cantrell's criminal record.
Okay. Any objection to plaintiff's Exhibit 21 for identification?
Yes, Your Honor. I believe that to enter an exhibit on the record or to show it to the jury, that this may count against the team's allotted time, and we ask that that only be done when the record has started.
Okay. In other words, you don't want this argument to count again. I mean, so you don't have any objection to the admissibility of Exhibit 21. This is in the nature of a motion in limine, an affirmative motion in limine to allow an exhibit in evidence. He's fronting it to the court in advance of the trial. So it sounds like you don't have any objection to the exhibit itself.
I do have an objection to a part of the exhibit, Your Honor.
Okay. Well, let's not talk about the ministerial issue at the time. But let's talk about what's your objection to part of the exhibit?
Yes, Your Honor. The last charge on the criminal record was dismissed because of a lack of evidence. We ask that this be constructively redacted from the document, as it serves no probative value to the actions of Drew Cantrell, but only serves to prejudice the jury against it.
All right. What was the, remind me again what the dismissed portion of it was again?
It is possession of a concealed firearm, Your Honor, and defense counsel is correct, it was dismissed, so we would be more than happy to issue a limiting instruction or to constructively redact that portion of the exhibit, as long as the first three sustained charges.
Yeah, let's constructively redact that portion of the exhibit. I don't want any, even though it was dismissed. I mean, prior bad acts aren't limited to acts of which a defendant is convicted. If they happen, if they can be proven by preponderance of the evidence, if there's some evidence to support them, they can still be admissible to show character under 404B. But in this case, since there's no objection, the jury will disregard any evidence that dismissed charges and at least constructively redacted and instructing the jury to disregard any evidence that dismissed charges. Any other housekeeping matters?
No, Your Honor. Would Your Honor like a copy of Exhibit 21?
If you have one, yeah.
Yes, sir.
Would. Thank you.
May I publish to the jury?
Well, I think it would probably be appropriate to do that during the trial, I think.
Yes.
I mean, I think maybe when Mr. Cantrell is on the stand, because we're not quite at the housekeeping stage, so not at this time.
Yes, sir.
But it will be, I'm going to allow its admission with that constructive deletion. Any housekeeping matters from the defense?
Yes, Your Honor, briefly. We just ask that in accordance with Rule 615, all non-party witnesses be constructively sequestered from today's trial.
Yes, absolutely. That'll be granted. We call it a motion to exclude witnesses here in Illinois. That the reason for that, of course, being that if non-party witnesses heard the testimony of other witnesses, it might influence their testimony. So we will constructively exclude witnesses from the trial for purposes of this exercise. They can physically remain here if they want, but they're constructively excluded. And we will contend that they did not hear the testimony of the other witnesses, which may or may not influence their testimony. Anything else?
With that, the defense is ready to proceed.
Okay, great. All right. All right, counsel for Carbo, you may proceed. I'm sorry, hang on a second. I'm reading. Okay. Counsel Justice Carbo, you may begin your opening statement.
Yes, Your Honor. May it please the court, opposing counsel, and members of the jury. The warning signs were all there. It's May of 2020, inside a local college, place where people go to learn about safety. Safety instructor is teaching a new student how to safely handle firearms. The student stands where he's told and watches as the instructor begins to learn. But what the student doesn't is that this instructor has a long history of careless and irresponsible conduct. But what the student doesn't is that this instructor has repeatedly violated fundamental gun safety rules in the past. And what the student doesn't, but what she couldn't, was that this instructor was in the process of violating yet another safety. Except this time, someone was going to get hurt. As the instructor aims down range, she fires a shot, but loses control of the gun, and the second shot is fired. But that second shot, it isn't fired down range towards the target. It's fired backwards at the student, and it hits that student in the leg, causing a severe and permanent injury. But what's even worse is that, as the evidence will show, the instructor's employer, the defendant, shooting star gun club, he knew that this instructor was unfit to teach firearm safety because the warning signs were all there. But it still chose to put a gun in that instructor's hands, and which is why that student, my client, Miss Justice Carbo, decided to file this lawsuit against Shooting Star LLC for negligent hiring and retention and the reckless entrustment of a firearm. Because the warning signs were all there. I'd like to introduce you to that student, Miss Justice Carbo. This is Justice. She's 34 years old. She was born and raised just a few blocks west of here. And until this incident I just described, she ran marathons. Now she can barely walk without limping. As the plaintiff, it is our burden to prove to you that it is more likely true than not that the defendant hired and retained a woman named Drew Cantrell as a firearm safety instructor, despite the fact that she was unfit, and that this employment caused Ms. Carbo's injury. We will meet our burden by proving 3 facts. Fact number 1, Drew Cantrell was unfit to teach firearm safety. Fact number 2, the defendant knew or should have known of Ms. Cantrell's unfitness. And fact number 3, the defendant still put a gun in Ms. Cantrell's hands to teach Ms. Carbo. Let's take those one at a time. First, that Drew Cantrell was unfit. To prove this to you, we are required to talk about something uncomfortable. Ms. Cantrell's character. Whether she was a safe person or a terrorist. We will prove to you that Ms. Cantrell was unfit due to a character of terrorism. 3 separate previous criminal convictions of reckless and unsafe conduct. Fired for being drunk on a past job. And even after being hired by the defendant, she committed critical gun safety violations. Today, you'll even hear from an expert who will testify and tell you that in his professional opinion, she was unfit to teach firearm safety. And the second fact, the defendant knew or should have known of Ms. Cantrell's unfitness. When she was hired, Ms. Cantrell authorized the defendant to conduct a background, which would have revealed the pattern of careless criminal conduct. But either the defendant failed to do this check, or if it did, it ignored it. An eyewitness will confirm that the defendant's owner saw Drew Cantrell aim a gun at another coworker, but then 3 months later promoted her to firearm safety instructor. And even after that promotion, Shooting Star continued to employ her despite her breaking of several gun safety. Which brings me to the third fact. Despite all the warning signs, the defendant still chose to put a gun in Ms. Cantrell's hand. This fact will be undisputed. But the real question is why? Why did the defendant choose to put a gun in Ms. Cantrell's hands, teach Ms. Carbo, despite all of the warning signs? The answer is money. You'll hear today that the defendant's owner admitted under oath that Drew Cantrell's promotion was, quote, good on the check. All of this is why, at the end of today's trial, my co-counsel, Mr. Penny Warren, will ask you to find the defendant liable for negligent hiring and retention and the reckless entrustment of firearms. Because all the warning signs were there. Thank you.
Thank you, counsel. Counsel for Shooting Star, you may proceed whenever you're ready.
Yes, Your Honor. Plaintiff's case, this is the law. In the opening statement you just heard, the plaintiff mentioned the name of Drew Cantrell 12 times. They talked a lot of Drew Cantrell's background in prior mistakes. But I'm here today to tell you, within the first 30 seconds of this opening statement, we're not here to dispute Drew Cantrell's past. Because here's the thing. Drew Cantrell is not the defendant in today's case. Shooting Star Gun Club is. And you may have missed that from the plaintiff's opening. And I understand why the plaintiff wants to make this case about Drew Cantrell. Because they can't prove one about causation. The plaintiff must prove you an unbroken chain of events that starts with Shooting Star and ends with the plaintiff being shot. Think of it like dominoes. The plaintiff must prove that Shooting Star knocked over that first domino in a series that ended with the plaintiff's injuries. But if the evidence were to show that somebody saying bump into that chain, causing the domino to fall over, that bump would be what's called intervening causation. Intervening causation breaks the chain of causation between Shooting Star and the plaintiff. And the evidence today will show that the plaintiff's actions were an intervening cause in their own injury. You'll learn today that the plaintiff ignored instructions on the range, moved closer to a shooter on the line, and then literally bumped the arm of the person about to shoot, causing the plaintiff's injury. So every time the plaintiff's counsel mentions the name Cantrell, I want you to remember what this case is really about. Causation. And to put it simply, the plaintiff's case misses the mark. When the plaintiff decided they wanted to purchase a firearm, they came to Shooting Star. Shooting Star is a local, small, family-owned business where employees and customers know each other on a first-name basis. 2 weeks before the plaintiff was shot, they came to Shooting Star and talked with the owner for over an hour. The owner explained safe gun handling
and paperwork the plaintiff would have to fill out in order to purchase a firearm. But the plaintiff couldn't just simply buy a firearm and walk out of the store. The owner scheduled a time for the plaintiff to come back in 2 weeks and take a safety lesson. And that's exactly what happened. On May 28th, the plaintiff came back to Shooting Star and was assigned to the safety instructor, Drew Cantrell. Now, you'll learn today that Drew Cantrell gave the plaintiff and another customer a safety. In that safety class, he explained safe gun handling and demonstrated that with a firearm. The evidence will show that Drew Cantrell placed the plaintiff several feet back into the room. But you'll learn today that the plaintiff ignored those instructions and moved right next to the safety instructor. While this was happening, Drew Cantrell squeezed the trigger, and the first shot went down towards the target as intended. While this was happening, the plaintiff jumped, bumping the instructor's right arm. The force of this bump caused the gun to go off again. And it's that second shot that struck the plaintiff in the leg. The plaintiff must prove to you an unbroken chain of events that starts with Shooting Star and ends with the plaintiff injured. Like I said, think of it like the domino. The plaintiff must prove that Shooting Star knocked over that first shot, and that no outside cause caused any of those dominoes to fall over. They must prove this by a preponderance of the evidence. They must prove that Justice Carter had no role to play in the shooting that took place. They must prove that the bump never happened. Now, I don't expect plaintiff to take that stand yet and tell you they never moved for the position where Drew Cantrell placed them. But I want you to listen to inconsistency where the plaintiff says they were when they were shot, and what Drew Cantrell and an outside witness, Avery Nguyen, tell you. Based off the plaintiff's opening, I expect that they will talk a lot about Drew Cantrell's past. Every time they do this, that misses the mark. Every time they bring up events that happened months or even years before the shooting ever took place, that misses the mark. So every time the plaintiff brings up the name Cantrell, I want you to be asking their attorneys, what about causation? Everyone here can sympathize with the plaintiff. No one is trying to say the plaintiff deserved to be shot. No one's trying to diminish the pain the plaintiff went through. But that does not mean Shooting Star is responsible. You took an oath at the beginning of this trial, set aside your feelings, and judge this case based on the facts. I know that you will do this. That's why I'm confident that at the end of today's trial, my co-counsel Patrick Colligan comes before you to ask you to bring back a verdict not liable. You will. Thank you.
Thank you, counsel. First, going to take a 2-minute recess. I'm going to give the jurors a chance to enter their scores. Court will be right back. All right, but we will be ready to resume straight away. Carbo may present your case as per the special instructions. You require to call Justice Carbo as your first witness. Are you ready to proceed?
Yes, Your Honor.
Okay, you may call your first witness.
Yes, Your Honor. The plaintiff calls Miss Justice Carver.
Carbo, remain standing and raise your right hand. You solemnly swear or affirm the testimony about to give in this proceeding to the truth, the whole truth, and nothing but the truth.
Yes,
You may be slow your right hand and be seated.
May I proceed, Your Honor?
You may.
Please tell us your full name and spell your last name.
good afternoon. My name is Justice Carver. That's Juspice.
Could you tell the jury a little bit about yourself, Miss Carbo, where you're from?
Always lived in Imperial State. Actually, the lead manager at the Imperial State Library. I'm in charge of keeping track of the books, that kind of thing. I also always ran track in high school. I really have a passion.
How old are you, Miss Carbo?
I'm 34.
And are you the plaintiff in today's case?
Yes, I'm suing Judy Carver.
I'd like to talk a little bit about why we're in court today. Could you explain to the jury briefly why we're here?
On May 28th of last year, I went into Shooting Star to buy a gun. And I ended up getting shot.
Well, Ms. Carver, I'd like to back up and could you tell the jury what originally motivated you to purchase a gun?
Unfortunately, around last year, I was experiencing a lot of break-ins in my neighborhood. On my way home from the library, someone tried to steal my books. I really just wanted to purchase a gun to be safe.
Was there anything that specifically intrigued you about Shooting Star Gun Club?
All the things I heard about Shooting Star were mostly positive. I also saw a commercial about how good they were on.
Your Honor, I'm showing opposing counsel exhibit 13. Approaching the witness. Ma'am, could you tell me what exhibit 13 that I just handed you is?
This looks like a transcript of the commercial I saw.
And does it accurately reflect the wording of the commercial as you remember when you watched it?
It looks that way.
Your Honor, the plaintiff offered exhibit 13 in evidence.
Any objection?
No objections. Your Honor.
Okay, plaintiff's exhibit 13 for identification will be.
Yes, Your Honor. Ma'am, what stood out to you about that commercial?
Well, in this commercial, Shooting Star said they teach us how to use guns like Meryl Streep or Michael Jordan. I really thought they were experts, so I went there to learn how to use a gun.
What did you do after you watched this commercial?
I emailed the owner, Skylar Coleman, about possibly buying a gun from them.
Did you ever visit Mr. Coleman in person?
Yes, the first time I visited him was around May 14th of last year.
And what did you do in the May 14th visit?
Mr. Coleman explained some basics about guns. I had a conversation with them, and then I asked them for a gun safety training course.
And did you receive a gun safety training course?
Yes, after asking, Mr. Coleman and I decided to reschedule my gun safety training course for May, about 2 weeks later.
When you came back to shooting star gun range on May 28th, what's the first thing that happened?
I went inside, I had to sign some paperwork. Mr. Coleman, I had to remind Mr. Coleman about the gun safety training course I asked for, and then he provided me that gun safety training.
Who was the instructor of that gun safety training course?
That was an employee, Drew Cantrell.
So after you were assigned Mr. Cantrell or Ms. Cantrell as your safety training, what happened next?
Ms. Cantrell, she took me to the gun range, of Booth 11, I believe, and there was another person there, Nick Allred.
After you arrived at Salt London, what happened?
Well, originally, Ms. Cantrell was just teaching us basic gun safety. And then she said she'd be demonstrating how to use a firearm by firing into the gun.
Ms. Carbo, what happened when she was going to demonstrate how to fire them?
Well, she raised the gun at the range. I heard one shot go off. And then the gun was pointed at me. I heard another shot.
What happened after you heard that second shot?
All I remember is a lot of pain. My leg went numb. I fell to the floor, and when I looked down, my leg was bleeding.
Thank you, Ms. Carbo. I have no further questions. Your Honor.
The cross-examination?
Yes, Your Honor.
You may inquire.
Carver, you remember visiting Shooting Star on May 14th, 2022?
Yes,
You spoke to the owner of the store, Skylar Coleman.
that's right, I did.
Mr. Coleman walked through the paperwork you need to fill out before purchasing a firearm.
Not on May 14th, we just had a conversation about firearms then.
Well, Mr. Coleman actually talked about the best firearm for self-defense that day, right?
That's right.
And he talked about stage gun handling, correct?
Yes,
Mr. Coleman spent over an hour with you that day,
yes, he did.
but you didn't leave the gun that day with, or you didn't leave the store that day with the gun, correct?
No, I asked Mr. Coleman for a safety training course, and then we rescheduled when I would buy my gun for day 10.
Right, so you and Mr. Coleman agreed you'd come back in 2 weeks to get your firearm,
Yes,
and you and Mr. Coleman agreed that you'd come back in 2 weeks to get a safety course, correct?
that's right.
You also filled out some paperwork on May 14th, correct?
I filled out some paperwork on May 20th.
With your sworn testimony, you didn't fill out any paperwork on May 14th.
I filled out paperwork on May 14th, but then the actual paperwork for my gun was on May 28th.
Well, I have that actual paperwork. I mean, did it 17, Your Honor? During closing counsel. Pershing. Mr. Honor,
Sure.
just handing you exhibit 17. This is document Mr. Coleman gave you, correct?
That's right.
You filled out this form,
I did.
you signed this form.
Yes, sir, I did.
Defense moves exhibit 17 into evidence.
Any objection?
Yes, Your Honor, as to hearsay, this is an out-of-court statement being offered for the truth of the matter it asserts.
Your Honor, may be heard.
Yes.
Your Honor, this is not hearsay pursuant to Rule 801(b)(2)(b). This is an adopted admission. As Ms. Carbo has just testified, she has signed this document.
Response?
Yes, Your Honor, her signature at the bottom, they've laid no foundation that means she adopts all of the contents in Exhibit 17. But rather than they might adopt a certain aspect of Exhibit 17, the rest of the document is still hearsay, Your Honor.
Hang on one second. How are these statements in this form offered for the truth of the matter asserted?
Your Honor, they're offered for the truth that she did purchase a gun, the type of gun that she purchased, and other statements that Mr. Coleman did when drafting that document.
But, well, first of all, by signing the statement, she acknowledged that she was purchasing a gun, right?
Yes, sir, yes, Your Honor, she acknowledged that portion of the document.
Okay, well, let's talk about the other portions of the document. How are those portions of the document statements of the truth of the matters asserted in the rest of the form?
Well, if they aren't offered with the truth of the matter, sir, Your Honor, then I would object to relevance, as it has no relevance to the retention and hiring of Drew Cantrell or to the claim that the defense is pursuing in this case.
Your Honor, if I may.
Amen.
Your Honor, as this objection has shifted to a relevance objection. This is a case in which plaintiff's second cause of action is the question as to whether or not Mrs. Carbo was recklessly entrusted with a firearm. However, what this shows, this makes it less likely that was the case, as the store had made her fill out paperwork regarding her fitness to have a firearm, making sure that she meted various qualities in order to be entrusted with the firearm, or to be sold with the firearm.
I have a pretty wide berth for relevance objections, so I agree with counsel that it is legally and logically relevant. I have less of a wide berth for hearsay, if it is hearsay, but I'm not sure that these statements are offered for the truth of the matter. Sure, it's just a form that she signed, so there are any admissions, the adopted admissions. So I'm going to overrule your objection and allow Exhibit 17. Are you offering it into evidence now, or just to show? Are you just offering for the purposes of impeaching the witness, or are you offering it in evidence?
I'm offering this into evidence, Your Honor.
Okay, and Exhibit 17 for identification, defense Exhibit 17 for identification will be admitted into evidence as defense Exhibit number 17.
And members of the jury, if I could direct your attention to the Zoom. We could permission the public to the jury, Your Honor.
Yes, you may.
Ms. Carbo, top left of this statement of this document says U.S. Department of Justice, correct?
Yes,
Now I want to direct your attention to box 21.
okay,
In box 21, you answered you've never been convicted of a felony, correct?
that's right.
Now I want to direct your attention to box 21H on the next page.
I'm there.
In box 21H, you answered you've never been committed to a mental institution, correct?
That's right.
Now I want to direct your attention to box 21K.
Okay.
Box 21K, you answered you've never been convicted of a misdemeanor domestic violence, correct?
That's right. I checked the box.
All your answers here are true.
Absolutely.
You can put that to the side. So you came back to shootings for 2 weeks.
That's right.
You filled out more paperwork like that one I just showed you.
That's right.
And you met Drew Cantrell.
Right. That was the instructor that taught my safety training.
And Ms. Cantrell took you to the stores in your brain, right?
He did.
She began by going over some safety instructions, right?
Yes.
And when you got in the range, no one was firing any weapons, correct?
No, nobody else was in there.
You were able to hear Ms. Cantrell's instructions, correct?
Yes, I was.
Ms. Cantrell began by demonstrating how to properly grip a firearm, right?
That's what she started with. Yes.
She told you to keep your index finger off the trigger.
Yes.
She told you to keep the barrel of the gun pointed downwards.
Right. She explained basic gun safety.
And she told you to treat every gun as if it were loaded.
That's right.
Ms. Cantrell demonstrated these things as she explained them, right?
Yes, with the gun that she showed.
Then she began to demonstrate how to aim and discharge the firearm. Now, it was around this point that you told you where to stand, right?
Yes.
Isn't it true you moved closer to Ms. Cantrell from the spot she put you?
Absolutely not. I stood exactly where Miss Cantrell told me to stand the entire time. I only moved when I was shot.
You didn't move from the position she put you.
No.
Don't we talk about that? I have exhibits 2G and 2H. Trying opposing counsel. Urging witness.
Sure.
I just handed you exhibits 2G and 2H, so let's start with 2G. That's a picture depicting where you're positioned at the ring, correct?
It looks that way. The red X looks like exactly where Ms. Cantrell's holding this thing.
Great. Very accurate depiction of the ring.
Yes, it is.
Now directing your attention over to exhibit 2H. That's a picture of the ring after you were shot, correct?
It is.
That's a very accurate depiction of the ring as it appeared after you were shot.
It looks that way.
Fencing with exhibits 2G and 2H is evidence.
Any objection?
No objection, Your Honor.
All right, exhibits, defense exhibits 2G and 2H for identification will be admitted as evidence as defense exhibits 2G and H.
So let's first, may I pose to the jury, Your Honor?
You may.
I want to first direct your attention over to exhibit 2G and those X's. The blue X, that's Miss Cantrell, right?
That's right.
That's where she was positioned in front of you to the left, right?
That's right. Drew Cantrell is standing on the blue X, I was on the red X, and Nick Oliver is on the yellow.
Okay, so you're the red X.
Yes, sir, I am.
Now that's where Miss Cantrell pulled your hand, right?
Yes, that's exactly where she told me to stand.
And that's exactly where you stood, right?
Yes, it is.
And you stayed in that position until you were shot.
Exactly in that position.
Now I want to talk about how this happened. Exhibit 2H, that's a picture depicting, you would agree with me, your blood is next to the barrier separating stall 11 from stall 12, right?
That's what it looks like, yes.
So now, why don't we go back to 2G and those X's for a second? You agree with me, you were standing just behind Drew Cantrell, right?
Yes, sir, yes.
And you were just off to her right?
Yes.
Now, Miss Cantrell, your safety instructor, she held the gun like this, didn't she?
I'm sorry, sir, I can't see what you're doing. I apologize.
Exactly. No further questions, John.
Any redirect based on that?
No redirect, though.
Okay. Ms. Furbo, you are excused as a witness. You may remain this is a party. You see at your discretion. We are going to take a few minutes to score. usual, all right, plaintiff may call, the next witness.
Yes, Your Honor. The plaintiff calls Dr. Morgan Judd to the stand.
Judge, you may step forward. Please remain standing, raise your right hand. Solemnly swear or affirm that the testimony about to give in this proceeding will be the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
Okay, you may lower your right hand and be seated.
May I proceed, Your Honor?
You may.
Good afternoon, Dr. Judd. Good afternoon. Will you please state your full name and spell your last name for the record? Morgan Judd, spelled J-U-D-D. Dr. Judd, what do you do for a living? I'm a researcher, professor at the School of Public Health at Imperial State University. Do you specialize in any particular public health field? Yes, sir. My specialty is gun violence prevention, and my academic research stands at the intersection of gun violence prevention and firearm safety training. Well, Dr. Judd, I'd like to talk about why you're here in court with us today. How are you involved in the shooting that occurred at the defendant's gun room? I was hired by Ms. Cabo to assess whether the firearms instructor that taught her, a woman named Z19's, was fit to teach firearm safety and at a more basic level, possess a firearm. Before we dive into your assessments, please tell the jury a little bit about your education. Of course. I have a master's from Auburn and a PhD in public policy from Tulane. And what experience do you have with firearms? Prior to getting my PhD and shifting to academia, I spent nearly a decade in federal law enforcement in the Bureau of Alcohol, Tobacco, Firearms, and Explosives. My ATF work focused primarily on illegal firearms trafficking, so I received extensive training in the various usages of firearms. Do you currently hold any gun safety certifications? Yes, sir. I have a firearm safety certificate from the Imperial Department of Justice. Your Honor, consistent with Section 12 of the court's pretrial order and Rule 702, the plaintiff tenders Dr. Judd as an expert in firearm safety.
Any objection?
No objection.
Your Honor. All right, the witness is accepted as an expert in firearm safety. You may proceed.
Yes, Your Honor. Dr. Judd, I'd like to return back to your assessments regarding the defendant's firearm safety instructor. Do you have the sufficient facts and data to reach conclusions about that employee's fitness to teach firearm safety courses and on a more broad level to handle firearms? Yes, sir. I did. I reviewed the deposition testimony and written statements of 5 different people with knowledge: Ms. Cabo, Ms. Cantrell, Mr. Coleman, the gun range, along with 2 eyewitnesses to the scene. I also independently reviewed all physical evidence. Did you reach your conclusions to a reasonable degree of scientific certainty? Yes, sir. What did you conclude about Ms. Cantrell's fitness to work as a firearm safety instructor? I concluded 2 separate things. First was that Ms. Cantrell was not fit to teach firearm safety due to a history of unsafe gun violations. And secondly, that shooting stars shouldn't have hired or retained them because they were knowledgeable of these violations. And did you reach any conclusions at all about Ms. Cantrell's fitness to possess a gun? Yes, sir. She was unfit to possess a gun due to the same history of serious gun safety violations.
Objection, Your Honor. More prejudicial than probative, if I may be heard.
You may be heard.
Yes, for under 403, for a piece of testimony to be relevant, it has to meet something called the helpfulness clause, which means it's helpful for the jury to make a decision on one of the charges. To tell the jury flat out exactly how they should answer on the specific charge of whether or not Ms. Cantrell was fit to use a gun has no help, does not help the jury at all to make that decision.
Any response?
Yes, Your Honor. It's Dr. Judd's testimony to how he came to his conclusions is highly relevant to the jury and has a substantially probative value to demonstrate to the jury how he came to those conclusions.
I agree with counsel for plaintiff. In addition, you've misstated the rule of evidence. It's more unfairly prejudicial than probative. Almost all evidence, the proponent of evidence is prejudicial. It has to be more unfairly prejudicial than probative in order to violate the strictures of Rule 403. So for that reason, I'm going to overrule the objection. You may continue.
Dr. Judd, I'll repeat my question. Did you reach any conclusions at all about Ms. Cantrell's fitness to possess a firearm? Yes, sir.
She was unfit to possess a firearm due to the same history of serious safety violations.
Well, I'd like to talk about that first conclusion you made, that Ms. Cantrell was unfit to work as a firearm safety instructor. Why do you conclude that?
There were multiple warnings, multiple examples of violating the most basic gun safety rules.
Why would breaking the most basic safety rules disqualify an individual from teaching a firearm safety course?
Well, you have to practice what you preach, but more importantly, it's about good judgment. Guns are obviously dangerous, and Ms. Cantrell's history of violations showed a flagrant disregard for the most basic core gun safety rules.
Were these safety violations signs that the defendant saw?
Absolutely, sir. They were all explicitly documented by shooting stop.
Would you recognize those documents if you saw them in court today?
Yes, sir.
Your Honor, I'm approaching opposing counsel with what's marked Exhibit 20 for identification. I'm also approaching Dr. Judd. Dr. Judd, could you please identify Exhibit 20 that I just handed you?
This is a warning letter from Skylar Coleman, the owner of Shooting Star, to Drew Cantrell. It has multiple gun safety violations.
And is this a fair and accurate copy to your best knowledge?
Yes, sir.
Your Honor, the plaintiff offers Exhibit 20 for evidence.
Any objection?
No objection, Your Honor.
All right, exhibit 20 for identification will be admitted in evidence as plaintiff's exhibit 20.
Yes, Your Honor. Dr. Judd, how many safety violations are discussed in that letter?
Two separate ones. The first one is in May, and the second one is in November. Both of them from 2021.
And just to be clear, was Ms. Carbo shot before or after these violations occurred?
This was in May of 2022, so after both of these violations.
Well, what were these violations?
The most serious one was in May of 2021, when during a verbal argument, Ms. Cantrell pointed a gun at another employee.
What is your professional opinion of that incident?
Intentionally pointing a gun at another person when you don't intend to shoot them is, from a safety standpoint, unimaginable. It's reckless and a violation of the core gun safety rule. You never point a gun at someone unless you intend to shoot.
Did the defendant terminate Ms. Cantrell's employment following this violation?
No, sir. In fact, she was promoted.
I'm sorry, Dr. Doug. But what do you mean by promoted?
You heard me correctly. During the incident, the gun pointing incident, she was a sales clerk. Less than 3 months later, she was promoted to be a firearm safety instructor, placing a loaded gun in her hands as part of a normal job responsibility.
Do you agree with that decision?
No, sir. The multiple warning signs were obvious and clear signals that she couldn't have been hired.
Why did the defendant choose to promote an employee with Ms. Cantrell's violation?
It was a financial decision.
Objection, speculation?
Sustained.
Yes, Your Honor. Dr. Judd, in your preparations for this case, whose deposition did you read?
I read the depositions of Skylar Coleman, along with 2 eyewitnesses, and then Cabo and Henry.
And in reading Mr. Coleman's deposition, what reason did he give for promoting Ms. Cantrell?
He stated that it wasn't bad in the textbook.
Objection, say?
A response, Your Honor?
Yes.
2 things. First, the statements by Skylar Coleman are definitionally not hearsay under Rule 801D2, party opponent. And second of all, it has been pre-stipulated in pre-trial order number 11 that all statements by Ms. Coleman apply vicariously to this case.
Any reply to that?
Withdrawn, Your Honor.
Okay. The objection is withdrawn, the answer will stand. The jury will disregard, by the way, the objection that I sustained and speculated to disregard the answer. Was with respect to the previous question.
Dr. Judd, as you were saying?
As I was saying, Coleman stated explicitly that it wasn't bad in the textbook, demonstrating a financial motive.
Well, I'm sorry, Dr. Judd, I'm confused. How does money factor into gun safety decisions?
It shouldn't.
Well, Dr. Judd, following the defendant's promotion of Ms. Cantrell, did these violations stop?
No, sir. There was another violation in November 2021, in which Miss Cantrell brought a loaded gun into the main shopping area and out of the range, once again violating a core gun safety rule. Never keep a gun loaded unless you intend to fire.
Was the defendant made aware of this second violation?
Yes, sir. This violation is also documented in this memo.
Did Shooting Star terminate Ms. Cantrell's employment following the second violation?
No, sir. She was detained.
Did Shooting Star at least remove Ms. Cantrell from her position as firearm safety instructor?
No, sir.
Dr. Judd, based on your expertise in firearm safety, do you agree with any of the defendant's decisions regarding Ms. Cantrell's employment as a firearm safety instructor?
No, sir. I do not. There is no margin for error when it comes to gun safety. They violated some of the most absolute rules, the most basic rules of gun safety. You don't keep a gun loaded unless you intend to fire it. And you don't intentionally point it at someone unless you intend to shoot that person. Both of those in tandem demonstrate that he was unfit to possess a firearm and teach firearm safety.
Thank you, Dr. Judd. No further questions, Your Honor.
Thank you, counsel. Cross-examination.
Dr. Judge, you're being paid to testify here today?
Yes, sir.
You're being paid $14,400 for your analysis.
Not just that, also a $6,000 flat fee.
And on top of that, you're charging $600 per hour for the time you spend in court.
Yes, sir.
So all in all, you're being paid about $21,000 by the plaintiff.
$20,000. It depends on how much time I have to find court today.
Well, assuming you spend 1 hour here, it's $21,000.
Assuming I spend 1 hour, yes.
But Dr. Judd, money isn't the only reason you're testifying, right?
Yes, sir.
In 2011, a member of your family was killed by a stray bullet from a nearby shooting.
Yes, sir. She was.
It was after this accident that you decided new gun safety laws were necessary.
Yes, sir.
It was after this accident that you decided to get involved in political advocacy for gun safety laws.
Yes, sir.
One of the laws you advocated for was the Responsible Firearm Sales Practices Act.
That's correct.
Not only did you advocate for it, but you also did some of the research.
Yes, sir. As part of my advocacy.
And now you're here testifying about how that law should be enforced.
Yes, sir.
As part of your analysis, you had to outline best practice for safely using a gun. Is that right?
Yes, sir. There were 5 separate things.
Well, in your report, one of the things you mentioned was that the gun must remain unloaded at all times except when in use.
Yes, sir.
And you have no reason to believe that Mr. Cantrell broke that rule on May 28th of 2022.
No, sir. I disagree.
You have reason to believe that he broke that rule on May 28th of 2022?
Yes. He didn't intend to shoot her the second time. He didn't intend to shoot her the second time. The gun should have been unloaded.
Dr. Judd, let me be clear. The gun was in use and it was loaded. When it wasn't in use, it wasn't. Is that right?
Yes, sir. And it shouldn't have been loaded because it's going to shoot someone unintentionally.
Now, Dr. Judd, you also mentioned that the firearm safety mechanism must be used properly by the operator.
Yes, sir.
And you have no reason to believe that Ms. Cantrell ever broke that rule.
Using the gun correctly? No. The spacing of Miss Carbo is a separate issue.
All right, well, I just want to be thorough, so let's go through all of what you said. You also mentioned that a gun must be used with the proper type of ammunition.
Yes, sir.
And you have no reason to believe that Ms. Cantrell ever broke that.
Yes, sir. Ammunition used is correct.
You also mentioned the firearm must be used along with eye and ear protection.
Yes, sir. Among other protections.
And Ms. Cantrell did that, right?
Yes, sir. She had ear protection and correctly. The issue came when they came out in the topic.
We'll talk more in depth about these in a second. But for now, my question is, you never interviewed anyone in this.
No, sir. I didn't need to.
You have no reason to believe that Miss Cantrell did this on purpose.
Not that I,
Accidents can,
absolutely.
even the most experienced marksman still has accidents.
The most experienced one shouldn't have accidents. That's a bad thing.
Dr. Judge, is it your sworn testimony that experienced marksmen will not experience accidents?
No, sir, my testimony is that they certainly can, but they shouldn't.
So that's a yes. Even the most experienced marksman can still have accidents.
Yes, it's always possible.
No two firearms handle the same.
Yes, sir. All of them vary based off things like brand, label, age.
Dr. Judge, not even two firearms of the same make and model handle this.
Absolutely, based on those three other criteria I've mentioned.
Dr. Judge, now I want to talk about the Responsible Firearms Sales Practices Act. Under the law, one of the qualifications that could render someone unfit would be age. Is that right?
Yes, sir.
Ms. Cantrell's age was not a concern?
The age wasn't an issue, so prior safety violation for the
Again, Dr. Judge, we'll get there. But now I just want to be thorough. Ms. Carbo's age was not a concern either. What?
no, sir.
Another qualifying factor would be mental health concerns.
Yes, sir.
There was no evidence to suggest that Ms. Carbo suffered from a mental illness,
No mental illness.
nor was there anything to suggest that Ms. Cantrell suffered from a mental illness.
Yes, sir.
Now, another qualifying factor would be affiliation with the terrorist. Is that right?
Yes, sir. There were no affiliations with any of those.
That's right. There was no evidence to suggest that either Ms. Carbo or Ms. Cantrell had any kind of affiliation with the terrorist.
Yes, sir.
Now, another factor that could render someone unfit is experience, right?
Yes, sir.
In the case of Mr. Cantrell, he had been handling firearms for over a decade.
Yes, sir. His two past violations were the experiences that were bad, and I criticize.
Well, let's talk about it. As you mentioned, Ms. Cantrell had two firearm-related incidents.
One in May and another in November.
Two incidents in over a decade of using guns.
Yes, sir.
Let's talk about each of those incidents. Neither of them happened in the ring.
Yes, sir.
Is that correct? Neither of them happened in the ring?
Yes, sir. One was a verbal altercation. The other one was, in fact, taking it out of the.
And it's true that neither of them involved the discharge of a firearm.
No, sir.
That's a yes, neither of them involved the discharge of a firearm.
No, it's a yes. The question was worded really, but yes, neither of them involved the discharge of the fire.
Dr. Judd, it's true that neither of them resulted in an injury.
Yes, sir. They violated all safety rules. That was more than enough.
Well, Dr. Judd, Ms. Cantrell possesses a firearm safety certification. Is that right?
Yes, and an instructor's certificate.
Right. You also possess the firearm safety certificate.
Yes.
But you don't possess the firearm safety instructor certificate.
Yes, sir.
That's a yes, you don't.
As in, yes, I do. Yes, sir.
Now let's talk about Miss Carbo. You did have some concern with her lack of experience,
Yes, sir.
but she was sold a Glock 22, right?
She what?
This firearm is appropriate for inexperienced gun users.
Yes, sir. I know you see the gun being tested.
It's designed to be as easy to use safely as possible.
Yes, sir.
Thank you, Dr. No further questions.
So any redirect is.
No redirect, Your Honor.
That's what this means. That'll show you to step down. They remain in the room, if you so desire. I think our judges are going to take minutes to input their scores and comments. When the jurors have finished commenting and putting the scores, just look up and you're ready. Don't rush it. Ready? Okay, why don't you make all your 30 final minutes?
Yes, Your Honor. Plaintiff calls Mr. Ross Hernandez.
Hernandez. Order, please. Two words of Andy Solomon, swear or affirm testimony about the goodness proceeding to the truth and whole truth and nothing but the truth.
I don't.
You may lower your right hand and you see. You may inquire.
Good evening, Mr. Hernandez. Hi, how are you? I'm doing well, Mr. Hernandez. Tell us your name and spell your last name for the record.
Sure, my name is Ross Hernandez, it's spelled Sernandez.
How old are you?
I'm 40 years old.
Tell us a little bit about yourself. Where are you from?
Sure, so I was born and raised here in West Pasquale, but I'm Bostonian. My parents came from Southie back in the 80s for their work, and they never left. But we go back to the Cape every summer to visit with them.
What do you do for a living?
I own my own fresh seafood market. We call it Sapphire Shores Fresh Seafood and Lobster. We'll bring the taste back bay right here to the people of Imperial.
Now, Mr. Hernandez, I'd love to try your fish, but I'd like to talk about why you're here. Where's your business located in relation to Shooting Star Gun Club?
Sure, we're neighbors, basically. I'm located just right across the parking lot from Shooting Star.
Do you visit the defendant's gun room?
Oh, yeah, sure. I go to Shooting Star 3, maybe 4 times a week.
To use the gun?
Oh, no, sir. I've never owned a gun. I haven't even shot.
So then why did you visit the defendant's business?
Well, believe it or not, they have this little cafe. They call it Shooting McTavin's. You know, after that Adam Sandler movie. Anyway, I'll run over there for lunch and grab myself a frat, maybe a regular, or an ice cream with some chocolate chips on film.
Do you know the defendant's owner, Miss Skylar Coleman?
Oh, yeah, sure. I know Skyler. He's good people.
Do you ever talk shop with Mr. Coleman?
Sure. We're business folks. He and I have the same landlord. Don't get me started. But yes, we talk shop.
Has Mr. Coleman ever told you his ultimate goal for Shooting Star Gun?
Yes, he has. So I was, started seeing advertisements for Shooting Star around town, over a year ago. And I asked Skylar what they were about, and he told me, he says, look at Ross. We aim to put a gun in the hand of every citizen of Imperial.
Your Honor, I'm showing defense counsel what's been marked as Exhibit 8. I'm approaching. Mr. Hernandez, do you recognize Exhibit 8 that I just handed you?
Yes, I do. These are the gun range safety rules posted all over Shooting Star.
Is Exhibit 8 an accurate representation of the signage as you remembered?
Yes. What's it say?
The plaintiff offers Exhibit 8 evidence.
Any objection?
No objection, Your Honor.
All right, plaintiff's exhibit 8 for identification will be admitted in evidence of plaintiff's exhibit number 8.
Permission to publish a copy to the jury.
You may.
Now, Mr. Hernandez, during your visits to the defendant's business, did you ever cross paths with an employee named Drew Cantrell?
Yes, I know.
Did you ever observe Drew Cantrell break any of these rules?
Let's see. Yes, I did. It's the second one about only point at it if you want it destroyed, and this fifth one about if it's loaded, leave it on the.
Let's take those one at a time. First, you mentioned that Ms. Cantrell pointed a gun at someone. When did that happen?
That would have been in May of 2020.
What occurred?
Well, I was over at June's for lunch with a buddy of mine, and I heard some kind of commotion going on behind me. So I turned around to see what it was, and that's when I saw it.
Just to be clear, Mr. Hernandez, what did you see?
Well, I saw Drew. She was in some kind of discussion with the coworker over there. They were getting into it. They had some kind of. Anyways.
Objection, speculation.
Is that your own observation, Mr. Hernandez, or what are you basing that on?
Well, I saw they were having a fight behind this.
All right, I'll overrule the objection. Based on his personal observation, you may continue.
Mr. Hernandez, please continue your answer.
Sure. So I see that having this fight, and Drew's hand was by his side with a gun. And then suddenly, Drew raised her hand and pointed it right at the coat.
What happened after Miss Cantrell raised her arm and aimed the gun at the coat?
I'm telling you, it went completely silent. I mean, you could hear a pin drop. Everybody went completely mute. That was until the owner, Skylar Coleman, came in.
What did the defendant's owner do when Miss Cantrell broke this fundamental gun safety?
Oh, I mean, she really let him have it. I've never heard Skylar or anyone yell so loud.
Did the owner screaming calm the situation down?
Yes, yes. I've never been so relieved.
Now, I'd like to talk about the other relief event. Tell us about that. When did that happen?
Yeah, sure. So this is fifth one. Now, I should mention, I didn't actually see anything happen, but I heard it.
When did you hear that?
Well, that would have been in November of 2020.
And just to be clear for the members of the jury, what did you hear, Mr. Hernandez?
Well, I hear Scott. She was scolding Drew about taking a gun outside of the supermarket.
What exactly did the defendant's owner say?
Well, it was something like this. You are not allowed, under any circumstances, to bring a loaded gun outside of the range into the shop. You cannot do that.
Mr. Hernandez, could you read the very bottom of Exhibit 8 for the jurors?
Sure. It says, failure to abide by the above rules may result in removal from the facility and denial of future shooting permits.
On either of the occasions that you just described, was Miss Cantrell removed from the facility?
No, not that I know.
Did Miss Cantrell lose her shooting permit?
No, not that I believe. In fact, only a couple months after the May of 2021 incident, she was promoted to the instructor position.
Thank you, Mr. Hernandez. No further questions.
Counsel Cross.
Yes, Your Honor. May I proceed? Mr. Hernandez, you come to Shooting Star.
That's right, for that much. They make the best punch out of
And you're familiar with Shooting Star employees.
Yeah, sure. So,
One of those employees is Drew Cantrell.
that is true. I know.
Now, you're not quite a fan of Drew Cantrell.
I wouldn't say that. You just don't get along.
You find Drew Cantrell to be arrogant.
Yes, she is.
Now, you've also seen Drew Cantrell shoot in the range. Is that correct?
And that's right. 2 or 3 times.
Yes, you believe Drew Cantrell is not a good shot.
No, from what I've seen those 2 or 3 times, she was a wicked bitch.
But you have no experience with firearms.
No, I haven't shot.
You've never owned a firearm.
No,
Like you just said, you've never even shot a firearm.
That's correct. Like I said, I haven't shot.
And like you said before, you've only seen Miss Cantrell shoot 2 or 3 times.
Right, I saw her in the range 2 or 3 times. She shot multiple shots and they were missing by 3.
So that's a yes, it was only 2 or 3.
The 2 or 3 times I saw her shooting in the range.
Now, I'd like to move on to the event you mentioned moments ago. At that first event, you saw Miss Cantrell point a gun at another employee.
I did, yes.
Now, you were in the shop when this happened,
That is correct, yes.
but you weren't really paying attention to what was happening in the shop.
No, I saw it pretty clearly.
But you were not paying attention before to what was happening.
Well, there was a fight behind me, and so once I noticed there was a fight, I turned around and saw everything that happened.
Mr. Hernandez, is that a yes? You weren't paying attention to what was happening.
I was paying attention to what was happening.
Is it your sworn testimony that you were paying attention to what happened?
Once again, I was talking to a buddy of mine, and then I hears a fight behind me, and I turned around and saw what happened.
So that's a yes, it's your sworn testimony.
It is my, I'm sorry, can you clarify?
It's your sworn testimony that you were paying attention to what was happening in the shop.
Well, it's my sworn testimony that before I heard a fight behind me, I was talking to my buddy. And so I guess not paying attention to everything in the shop. But, you know, I don't have eyes in the back of my head. But as soon as I hear there's a fight going on behind me, I turned around and paid attention to what was going on.
Mr. Fernandez, I need a simple yes or no. Were you paying attention to what's happening?
Objection, Your Honor, asked and answered. Mr. Hernandez has already given response to this question.
Well, he did, but it was maybe a little bit evasive. I'm gonna let him ask it one more time. I understand your objection. So answer the question again, Mr. Hernandez, if you can.
You were not paying attention to what's happening in the shop before Drew Cantrell pointed the gun at another.
Not when I came in the shop, I kind of was looking for some more clarification here. What time frame were you looking at?
Mr. Fernandez, you had been talking to your friend when you got here.
I was talking to my friend, and then I heard a fight behind me. I paid attention to what was going on.
Mr. Fernandez, you cannot tell us what this fight is about.
Not exactly. I know it was.
So that you know, you cannot tell us what this fight is about.
Can't tell you exactly what was discussed, but I know it was a fight, yes.
But what you can tell us is that Drew Cantrell said the gun was unloaded.
Yes, I heard later that it was unloaded.
Now, Skylar Coleman, the owner, she reprimanded Drew.
As far as I know, there was a written report and some verbal reprimand.
And Drew Cantrell never repeated the thing.
Well, not that I know. I'm not an advocate.
Well, I'd like to move on to that second event you mentioned. Drew Cantrell brought a loaded gun out into the shop.
That is correct, yes.
You weren't at the shop when this happened?
No, I only heard
it. You only heard about it when you came into the shop later and overheard Mr. Coleman and Justice Carter. I mean, Drew Cantrell.
That is correct, yes. I heard Mr. Coleman chastising Mr.
When you entered the shop, it was.
That is correct, yes.
There was no one in the shop.
No one in the shop. No,
no customers. No.
Not when I heard Mr. Coleman chastising me.
And after correcting Drew Cantrell never repeated it.
Again, I would have no idea. Not that obvious.
Thank you. Nothing further.
You were direct on that?
Yes, Your Honor. Mr. Hernandez, I just want to clear up something you said about the May of 2021. When were you paying attention and when were you not paying attention to the situation behind you?
Of course. So I was there to be one but it's like then I hear something going on and I shift my attention from my buddy to the confrontation that was going on.
And now, Mr. Hernandez, did you know what the fight was about?
Not exactly, but I could tell it was.
What exactly did you see?
I saw Cantrell lift her hand and point it with the gun at the other coworker there.
Thank you, Mr. Hernandez. No further questions.
Any reprocess on that?
Nothing further, Your Honor.
Okay, you may step down, Mr. Shin. All right. As per Empyrean regulations, I understand that the plaintiff rests this time. We will take no more than a 5-minute break unless either side has an objection. Timekeepers, please start the clock for 5 minutes.
We already count real quick. 24. I think. Good. 5 minutes has passed your.
It's elapsed. Okay. All right, is it defense ready to proceed?
Yes, Your Honor.
Okay, you may call your first.
Defense calls Drew Cantrell to the stand.
And you solemnly swear or affirm the testimony about giving you pursuant to the truth and whole testimony about the truth.
I do.
In your lower right hand and be seated. Inquire.
Please introduce yourself.
Good evening, my name is Drew Cantrell.
Ms. Cantrell, who at Shooting Star Gun Club when the plaintiff was shot?
Yes, I was there in my capacity as a safety instructor.
Before we get into that, can you tell the jury a little about yourself?
I lived here in West Hospital and very much in the life. Guns have been something that I love my whole time.
You mentioned that you're an employee at Shooting Star. When did you first apply there?
I first applied as a sales clerk in June of 2020.
Before you were hired, was there any interview?
Yes, I had an hour interview with Skylar Coleman before I was there.
What sort of things did you tell Skylar Coleman within this interview?
Well, first of all, I told him about my extensive background with us. I also told him that I managed the storage at my on the mechanic shop that I used to work at. I also told him that about my work ethic and what I would bring to Shooting.
And just to be clear, who is Skylar Coleman?
Skylar Coleman is the owner of them.
Were you ever given the position at Shooting Star?
Yes. A few weeks later, I received a phone call of Skylar Coleman telling me that I was hired as a staff.
Now, did your position at Shooting Star ever change from a sales clerk to anything else?
Yes. In August of 2021, I was promoted as a safety instructor.
And was there any other requirements you needed in order to become a safety instructor?
There was. I first needed to obtain my firearm safety certificate, which I did in November of 2020. Then I filled out a few forms to receive my firearm safety instructor certificate.
Maybe Exhibit 19. Showing the opposing counsel. Approaching the witness. Did Your Honor like a copy?
Sure.
What did I just hit?
You handed me my firearm safety certificate.
After earning this certificate, did you present it to Shooting Star?
Yes, I had to be able to confirm with Skylar Coleman that I was certified to become a firearm safety instructor.
And is this a fair and accurate copy of that certificate?
Yes, it is.
The defense moves Exhibit 19 is evidence.
Any objection?
No objection, Your Honor.
All right. Defense exhibit 19 for identification will be admitted in evidence as defendant's exhibit number 19.
Permission to publish the jury?
You may.
Now, according to the top of this document, where does it say it's from?
It says it's from the Imperial Department of Justice.
And looking a little further down, when does it expire?
It expires on November 15th of 2025.
You can set that aside. I'd now like to shift your attention to the day of May 28th, 2020. You remember that day?
Yes, that was the day Justice Parker was shot.
When exactly was Justice Carver shot?
He was shot during one of my safety instructions.
Can you please explain to the jury what exactly these safety instructions entail?
So my safety instruction has three parts to it. Our first part is me going over our rules and handing my students their protection equipment, the earmuffs and the goggles. Then we go over the rules and then demonstrate how to follow these rules. And then I would teach the students how to shoot the weapon, shoot an aim.
Now, that first part, what sort of instructions did you give to the class?
I shared three rules with Justice Cargo and Nick Robert. The first one I told them was to treat every gun as if it's loaded. The second rule was to always keep your finger off the trigger unless you intend to shoot, and always be sure of the target when you're aiming.
And how about that second step? Did you demonstrate this with a firearm?
Yes, I did.
Now, before we get into that third part, I'd like to talk about everyone's position on the ring. At Exhibit 2G, it has already been entered in heaven. Ms. Cantrell, you can please pick up G3. Looking at this, what exactly is this document?
Exhibit 2G shows where everybody was staying during the time of my arrest.
Who exactly does the red X represent?
The red X represents Justice Cargo,
And how about that yellow?
and that shows the position of Nick Alred.
And the black?
That shows where I was.
Now, did Nick Alred ever move from the position you placed him?
No, he didn't.
How about the plaintiff? Did the plaintiff ever move from the position you placed him in?
Yes, she did. She was closer throughout the duration.
And after Ms. Carbo moved closer, what exactly happened?
I got ready to fire the first shot. I fired, and I guess Justice Carbo must have flinched. And as she was close to me, she jumped into her left arm to my right arm.
And after the contact, did the gun go off again?
After it was falling out of my hand, the second shot.
And where exactly did that second shot go?
And went to Justice Carbo's head.
Now, Ms. Cantrell, how many times exactly did you pull the trigger to that Glock point?
I only pulled the trigger once.
Thank you. Nothing further.
Cross-examination.
Yes, Your Honor.
You inquire.
Ms. Cantrell, I want to begin with something that you mentioned on your direct examination. You're not 100% sure that Ms. Carbo moved. I got that right?
I am. I never moved my position throughout my course. Justice Carbo was the one who moved closer to me and then flinched when that fire shot me.
Is it your sworn testimony that you are 100% sure that you saw Justice Carbo move?
I didn't see Justice Carbo move, but she did move closer to me.
So just to be clear for the members of the jury, you never saw Justice Carbo move from where you told me to stand, that's right?
No, but I know she flinched and hit me.
Now, prior to working at the defendants, you had never worked as a firearm safety instructor anywhere else, that's right?
No, but I did have an extensive experience with guns as I used to go through the department.
But that's a yes, you never worked as a firearm safety instructor anywhere else, that's right?
No, I haven't.
And not only have you not worked as a firearm safety instructor, you also had a history of not following safety rules, that's right?
Could you explain that a little bit?
Well, man, you would agree that traffic laws are in place to ensure public safety, wouldn't you?
Yes, there is.
Your Honor, permission to publish exhibit 21 to the jury is already in evidence.
You may.
In pushing witness. Ms. Cantrell, just to be clear, that is your criminal record, correct?
Yes, it is.
It's an accurate copy of your criminal record?
Yes.
This criminal record shows that around the time you applied for a job with the defendant, that you already had a history of not following safety rules, that's right?
Yes, these were mistakes that I made when I was younger and not learned.
In 2014, you pled guilty to reckless driving, that's right?
But reckless driving has nothing to do with the way I teach my courses. But that's a yes, you pled guilty to reckless driving?
Yes, sir.
You wanted to test and see how fast your car could go. So you intentionally ran a red light, that's right?
Yes, but again, I was 19 at the time. I made my mistake.
In 2016, you pled guilty to a hit and run, right?
Yes, sir.
You sideswiped a parked truck and then continued driving, that's correct?
Yes, but I was, 21 at this time. I was being immature.
In 2018, you pled guilty to driving while under the influence of alcohol, that's correct?
Yes.
Ms. Cantrell, reckless driving, hit and run, DUI, none of these are examples of careful behavior. Do you agree with that?
Correct.
Objection, argumentative.
It's cross-examination, it's a little bit argumentative. I don't overrule the objection. The answer will stand.
Just to be clear, ma'am, reckless driving, DUI, and hit and run, you would agree that none of these are examples of careful behavior, that's right?
Yes, that's correct, but I was young at the time. I was immature. I wasn't really thinking about the decisions I was making.
And prior to being interviewed by the defendant for your job at Shooting Star Gun Club, you had just been fired from your previous job for being drunk on the job, that's right?
That's what I was.
Objection to more prejudicial, more unfairly prejudicial than probative.
Response?
Yes, Your Honor, this is certainly highly probative and outweighs the prejudicial value. And it's certainly not more unfairly prejudicial to the jury, as this is a negligent retention and hiring case. And it's important for the jury to know whether her being fired for being drunk on the job had any effect on her hiring or retention at Shooting Star.
Can you reply?
Your Honor, this is specifically more unfairly prejudicial because it includes the mention of Miss Cantrell being drunk. There's absolutely no evidence on the record to show that Miss Cantrell was drunk on the day of May 28th, 2022, or that anyone else on the range was.
Yeah, I'm going to sustain your objection for this time, and I'm also going to constructively redact the guilty plea to the DUI in her anything. I'm going to ask the jury to disregard the DUI, that consider the reckless case. I don't remember any objection to the DUI charge at the beginning, so I'm going to instruct the jury to disregard the guilty plea to the DUI as opposed to the reckless conduct and the other charge you plead guilty to. So I'm gonna sustain that objection. I don't think intoxication is relevant. So the objection is sustained. You may continue.
Yes, Your Honor. And then just to be clear, Mr. Cantrell or Mr. Coleman never asked you why you left the previous job, right?
No, she didn't.
And I want to move on and talk about other instances of conduct. Now, and after you were hired by Shooting Star, your unsafe behavior continued, didn't it?
I made one mistake in my occupation as a sales clerk, but that mistake never.
Our person witness with exhibit 8. Permission to publish exhibit 8 to the jury.
Which one's exhibit 8 again?
It's the rules, Your Honor.
Okay, that's already been in there. So you may publish it. Yes.
Ms. Cantrell, just to be clear, in May of 2021, you violated the second rule on that list by aiming a firearm at another person in the shop, right?
I wasn't aiming it at another person. I was aiming at the grounds that she thought I was pointing it at.
Just to be clear, Mr. Coleman came into the room and yelled at you to never point a gun at somebody in the shop ever again, right?
Yes, she did, but it was just a big mistake.
He even formally wrote you up for that incident, that's right?
Yes, she did.
And you can see at the bottom there, where that it said that any violation of these rules could result in removal from the facility or denial of future shooting privileges, that's right?
Yes, it may result, but not for sure.
Just to be clear, after that May 2021 incident, you were not removed from the facility, were you?
No, yeah, this says may result. I mean, it doesn't mean for sure that I would be removed or lose my shooting privilege.
You were not denied any future shooting privileges?
Correct, I was.
You were not provided any extra training after that?
No, I wasn't.
You were not punished in any other way than verbally, that's right?
No, and I had the memorandum written for me.
Ma'am, just 3 months after that incident, you committed yet another safety violation, right?
It was another misunderstanding.
And this was after you had already become a firearm safety instructor, that's true?
Yes.
It's the fifth one, because you brought a loaded gun out of the shooting range and into the storefront, that's correct?
Yes, but at the time of this incident, the shop was empty and my finger was never near the.
But that's a yes, you violated one of Shooting Star's gun safety rules, that's correct?
Yes, it did, but the shop was empty and my finger was not on it.
You were not removed from the building, were you?
No, I wasn't.
You were not denied any future shooting privileges.
No,
You were not trained any further, that's correct?
no, I wasn't.
Now, I'd like to turn your attention to the day in question, May 28th of 2022. And that day is when you met Ms. Carbo for the first time, that's right?
Right, I'm being introduced as her safety instructor.
You took her brand new Glock 22 and you brought it into the shooting range, that's right?
Right, to start the lesson.
And just to be clear, if I understand, ma'am, it's your testimony that that Glock 22 fired with harsh and unexpected recoil, that's right?
Yes, it did, but I was able to, maintain my grip and absorb that.
Well, man, when you shot that gun, you fired that first shot, the recoil shifted your hand slightly to the right, that's correct?
But again, I was able to maintain the recoil and bring it back.
It was only after your hand had moved to the right that you made contact with Ms. Carbo, that's right?
Yes, when Ms. Harper flinched and hit my phone right.
That is after your hand moved to the right, correct?
Right, but I was able to, absorb that recoil and bring it back.
You would agree with me that the function of a gun is fired, right?
Yes,
And the only way to test a gun is functioning correctly is to fire that gun, that's true?
correct.
Just to be clear, man, you never fired my client's brand new Glock 22 before teaching that training course, did you?
No, I hadn't. I had used a Glock 22 plenty of times before, so I didn't feel the need that day to check.
But not all guns are the same, you agree with that?
Yes, I didn't feel it.
And you would agree that if you would have fired that Glock 22 prior to the training course, you would have known about that harsh recoil, wouldn't you?
Maybe or maybe not. I didn't follow nothing, but didn't follow.
Man, that violates the second rule that we see on this list that says you need to always make sure that your gun is functioning correctly before you use it, that's right?
Correct, and I had used the Glock 22 before, so I thought it would be just, it would work fine before.
But you did not test the gun that my client had purchased prior to teaching training, that's right?
No, I didn't.
Thank you, Mr. Charles. No further questions, Charles.
Any redirect?
No redirect, Your Honor.
Okay, just can't tell you this stuff now. All right, defense, you may call your second witness. Actually, before you do, give the jury and myself a chance to put our scores. Here. Defense, you may call your second.
The defense calls Avery Nguyen to the stand.
Okay, please, remain standing. Here's your right hand. You solemnly swear or affirm that the testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth. Yeah, I do. Okay, let's see. You may inquire.
Please introduce yourself to the court.
Hey, how you doing? I'm Avery Nguyen. Please call me Avery, Mr. Nguyen, whatever you want.
Tell us about yourself.
Yo, born and raised in South Philly. My wife didn't move out here a few years ago, and I've been here since.
Why'd you move from South Philly to the state of Imperial?
Well, my wife kind of jabbed out here. I never heard of it before, but hey, it's good for hunting. I've been hunting all my life. I mean, the only things we got to hunt Saturday are the rats in the sewer, so it worked out.
Are you familiar with Shooting Star Gun Club?
Yeah, I am. I first of all didn't think it was a cigar shop, but after a while, I got familiar with the people and I've been coming out there for a while. Nothing's like getting out on the range, lining up that perfect shot and letting loose again.
So how exactly are you involved in today's case?
Well, I was on the range on May 28th, 2022. Hey, Blue King Truck Shop at Chicago.
Have you bought many guns from Shooting Star?
Yeah. My wife told me if I bring home one more gun, she's running divorce papers. So you figure that one out in the council.
Now I want to talk about what you've had to do when you first get done at Shooting Star. Have you had to take a background check?
Yeah, it's not different than buying guns back in Philly. There's a routine background check for every purchase.
Have you had to fill out any paperwork?
And I had to fill out paperwork. Only with every single purchase, I had to fill countless forms from the Bureau of Alcohol, Tobacco, and Firearms.
Have you ever been offered a safety course?
Yeah, I've been offered a safety course practically with every single purchase.
Where does that safety course take place, Mr. Lee?
The safety course takes place at the indoor range of Shooting Star.
And you mentioned Drew Cantrell earlier. How well do you know him?
I'm familiar with him. I know he's an employee. I've seen him walking around the course from time to time. As a matter of fact, he was the guy who was with justice when the going was.
Have you ever seen Mr. Cantrell mishandle firearms?
There was one occasion, if you want to even call it that.
What happened?
I was coming back from grabbing a grinder on the block. I walked in the shop. And I see Skylar Combs, CEO and the owner of the Shooting Star, yelling at her. I'm looking, and I'm seeing Drew holding a gun. Yeah, it looks like the barrel's facing towards the direction of someone else in the shop, but what I really remember was the way Skylar was chewing him out.
Now, how often are you at Shooting Star?
I'm there once or twice a week for sure.
Just to be clear, during all your time at the store and in the range, did you ever see anything like this happen again with Mr. Cantrell?
Nah. Drew never broke the rule after that yelling by Skylar. It was perfect behavior if they had to be honest.
Now, are there typically employees present at the range?
Yeah, to be honest, I can't remember the last time I had seen a few Shooting Star employees walking up and down the course.
Or where are they usually up to?
From what I see, they usually nag at people about following the rules and gun safety and whatnot.
Now I want to talk a little bit about what you saw on May 28th. What were you doing at the time?
Well, I was sitting over at a table behind stall 3, drinking some tonic and working on my lever action repeating rifle. We call them Matilda back at home.
I have Exhibit 2A. Working minutes.
Hey. All right, so
Your Honor,
Sure. This has not been previously made, correct?
no, Your Honor, that's when I just handed you Exhibit 2A. Do you recognize this?
yeah, I do.
What is it?
This is about the view I have of the whole incident. It's the range before the shooting had occurred.
Is it a fair and accurate depiction of the range as it appeared on May 28th, 2022?
It appears to me it is.
The plaintiff moves plaintiff Exhibit B into evidence.
Any objection?
No, Your Honor.
All right, defense exhibit, 2E for identification will be admitted as evidence as defendant's exhibit 2E.
May I publish to the jury, Your Honor? Taking a look at this exhibit, Mr. Williams, where were you?
I was sitting over at a table at stall 3, so right about where this blue trash can is at the bottom.
Where were Mr. Cantrell and Mr. Carbo?
They weren't that far. They were only at stall 11. The Drew was close to me, so right about here. And Justice on the right of him, so right about there.
Was anyone else with them?
Yeah, as a matter of fact, I was introduced to this Nick Galbraith fella earlier today. He was taking a safety course with them. He was on the right of justice, so did that be it?
I have exhibit 2H, which has already been entered into evidence. We're going to do have a copy of exhibit 2H.
Not that I can see.
Gonna put it down. First. May I share this to the jury, Your Honor?
You may, since it's already been admitted into evidence, yes.
Taking a look at this picture, what's this photo of?
This is the range after the incident had occurred.
Does the positioning of this blood accurately reflect where Mr. Carbo was standing during the shooting?
Yeah, it does.
So, Mr. Nguyen, what exactly happened leading up to this?
Well, I was looking first. I seen Drew demonstrate how to safely hold the gun. And that's when I seen Drew demonstrate how to safely aim the gun.
Did he shoot the gun?
Yeah. Drew fired one shot first.
What happened after Mr. Cantrell fired the first shot?
But when Drew fired the first shot, Justice kind of jumped.
Jump?
But when Drew fired the first shot, Justice jumped up in the air and bumped into Drew. And that's when the second shot was fired.
And when I want to make sure I get this very clear. Did the second shot fired before or after Justice Carbo bumped into Drew Cantrell?
Drew had fired the second shot just after Justice bumped into him.
Thank you, Mr. Nguyen. No further questions.
Thank you, counsel. Cross-examination.
Yes, John.
Inquiry.
Mr. Nguyen, I'd like to ask you about the events of May 28th, 2020. The events just described in our examination. So you didn't have the best view of those events, did you?
Yeah, but it wasn't a bad thing either.
But it wasn't the best.
Right? I mean, I can still see what was going on.
Your words are that it was not the best, correct?
Yeah, it wasn't the best view, but it wasn't the worst either.
In fact, you're looking out the corner of your eye, right?
Yeah, with multitasking. I was working on Matilda.
So yes, you were watching these events unfold out the corner of your.
Yeah, but I was keeping an idea what was going on around me. There was no one else there.
So Mr. Carbo, Ms. Carbo jumping, Ms. Cantrell's 2 shots, those are both seen out the corner of your eye, correct?
Well, yeah, but if someone's jumped in the air, I think you could see them.
Now, you testified that you're almost always offered a gun safety portion of your first gun, but that's not always true, is it?
Yeah, like I said, almost all the time. I mean, when I first started going, it was automatic, but going there over the years when I come, sometimes the owner scatters me go.
Exactly. In fact, the only times you were not offered that portion was when Skyler Coleman was selling you firearms, correct?
Yeah, but after all those years, I don't think I need it every single day when I'm walking in there. It don't make sense to me.
You consider yourself an experienced firearms, right?
Yeah, I would say that.
So you know the basic ground rules of how to operate a gun safely.
Yeah, of course I do.
And you also go to the Shooting Star about every weekend, like you testified to on your record.
Yeah, multiple times a week, sometimes days in a row.
So you're familiar with Shooting Star safety protocols, safety rules they have posted all over the shooting range, correct?
Yeah, I guess I'm familiar with them over the years.
Now, as a safe and experienced gun user, you follow these safety rules, don't you?
Yeah, I would hope so. Of course I do.
But you saw Drew Cantrell violate the second in May of 2021, correct?
What's the second rule?
Do you have a copy of Exhibit 8 up there?
Check. This it?
Yep, that's it. Would you mind reading the 2 signs that I read aloud? Only point at it if you want it destroyed. Always keep the gun pointed downrange and never point a gun at anything you are not planning to shoot. Did I read that correctly, sir?
Yeah, if he's like it.
Now, you saw Drew Cantrell violate this rule, correct?
No, not exactly.
Well, you saw Drew Cantrell pointing a firearm at another person, correct?
Do you want to hear what happened?
I'd like for you to answer yes or no to my question. You saw Drew Cantrell pointing a firearm at another person, right?
What I saw was I was walking in the shop and he had the gun facing up. Now, I don't know what he was doing with it. The barrel was facing towards someone, so you can say that.
He was holding,
But for all I know, he could have been reloading. I'm not sure.
he was holding a firearm, correct?
Yeah, he was.
And then the barrel was pointed at another person.
Yeah, but I didn't see him raise it up and he was just holding the gun out.
Sir, is it your testimony that he might not have been aiming a firearm at another person?
No, what I said was the barrel was facing towards someone. I said the gun was facing towards
Sir, I need a yes or no to this question. Your words, you would agree that he pointed a gun at another person, yes or no?
Yeah, I agree the barrel was facing towards someone.
And you agree that he pointed, right?
I walked in the shop and he was already there. I don't know that he
Sir, I need a yes or no to this question. You would agree he pointed it,
Yeah, it was pointing, yeah.
and it was pointed at another person.
Objection, asked and answered.
Overall, it's cross-examination.
That's a yes.
Answer the question.
He pointed the gun at another person.
Yeah.
And that is a violation of this rule too, correct?
He's like, yeah.
No further questions.
Let me read the record of that.
Briefly, Your Honor.
Very quiet.
You were asked a couple questions earlier about your view of the incident. How well could you see Mr. Cantrell in the photo?
I mean, I can see him pretty clearly. There was no one else in the shop at the time. All the stores were clear. And it was only about 30 feet away. So from here to that wall, we were there.
Thank you. Nothing further.
Any cross fifth on that?
Nothing further, Your Honor.
All right. Let's read the Here, for a chance to. Or- Okay, defense, you may call your final.
The defense calls Jack Stout to the stand.
Sal, thank you. You solemnly swear that the testimony about you proceeding with the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
You lower your right hand and be seated. Thank you. Remain quiet.
Good evening. Please introduce yourself to the court.
Good evening. My name is Jack Stout.
What do you do for a living?
I'm the CEO and founder of my own company, Stout Examiners. But despite that title, one thing that my 7 years of service in the Army has taught me is to never fight from the intent, always from the front. That's why I also serve as a head firearm tool examiner after the last 11 years.
How has your job brought you into contact with today's case?
Well, in November of 2022, the defense reached out to me and asked me to take an independent look at two matters. First, Mr. Cantrell's use of the Glock 22, and secondly, Shooting Star's sale of the Glock 22.
Before we get into all that, I first want to talk about your qualification. Tell us a little about your education.
Of course, I attended West, where I received a bachelor's degree in physics and a minor in photonics.
Now tell us where you've worked since.
In 2003, I was deployed in Iraq, where I served as an artillery officer for the Army. And after 7 more years, I was honorably discharged and attacked in 2010, just when I started my company, Stout Examiners.
What exactly does Stout Examiners do?
Stout Examiners has two main services as a company. We offer litigation support and forensic firearm analysis, and we also mainly educate everyday people on how to safely handle and how to properly discharge firearms.
What's your role at Stout Examiners?
Well, besides from being the owner, I specialize in firearm operability. preparing analysis for firearm-related incidents and certifying firearm safety by the Imperial Department of Justice and the United States Bureau of Alcohol, Tobacco, Firearms, and Explosives.
What facts and data do you review informing your conclusion?
I reviewed the depositions of Skylar Coleman and Justice Carlo. I reviewed the affidavits of Nick Allred, Drew Cantrell, and Avery Nguyen. I reviewed all exhibits, textual and photographic, and I also reviewed all videos before my conclusion to today's case.
And did you apply reliable principles and methods to those facts and data you reported?
Yes, sir. I used my decades of experience in handling firearms, my experience in firearm operations, and my training in firearm safety.
The defense offered Jack Stout as an expert in firearm mechanics. Per pretrial order 13, this court has already accepted him as an expert in that field.
Any objection?
No objection, Your Honor.
The court accepts Mr. Staub as an expert in firearm safety.
Mr. Stout, let's start by talking about Mr. Cantrell's experience. What experience did Mr. Cantrell have handling firearms?
Mr. Cantrell was a firearms safety instructor and he had over a decade of experience being around firearms.
Did Ms. Cantrell possess any kind of certification?
Yes, she possessed two certifications, firearms safety certification and firearms instructor certification.
Had Ms. Cantrell had any past gun-related incidents?
Yes, sir. I'm aware of two previous incidents, but there are two important things here. The error rate and the dissimilarity between these incidents and the incident that took place on May 28th of 2022.
Mr. Stout, what do you mean when you say that Ms. Cantrell's error rate is important?
Well, we're talking about someone who has had two accidents in the span of over a decade of being around firearms. And that's over 3,600 days of experience. And if you were to count an accident as a full day, that would still only give Mr. Cantrell an error rate of 0.05%. And the success rate would be 99.95%.
You also mentioned that Ms. Cantrell's dissimilarity. What did you mean by that?
What I mean by that is comparing these two incidents to the incident that took place on May 28th. During these two incidents, no firearms were discharged. No one was injured in either of the incidents. Neither of the incidents were repeated, and neither of the incidents took place in the range. So if you compare these two incidents, the incident that took place on May 28th, there are practically no similarities.
Now I want to talk about how Mr. Cantrell handled the glove. But first I want to be clear about what standard protocol actually is. What would be considered standard practice for safely using a gun?
In this case, it's really all about the grip. The operator should maintain a stiff and motionless grip. It should be tight, but not too tight, just enough to have a reliable amount of control over the recoil. See, to simplify it, when you fire a gun, it produces a kickback, and your hands are there to absorb that kick.
Then what would be considered bad practice when using a gun?
Bad practice would be considered holding the firearm loosely, not having firm control, without a firm grip, to result in an accident.
Why is it considered bad practice to keep a loose grip on a gun?
It's actually pretty straightforward. If there's nothing there to absorb the recoil that the firearm produces, you have to shift in different ways, and that could result in an accidental discharge or even the barrel facing different directions.
In this case, how could you determine how Ms. Cantrell was gripping the gun?
I determined this by considering Mr. Cantrell's movement before he took the shot, specifically sheath length of taking. Excuse me.
How can flinching be an indicator of someone's grip?
If someone were to flinch or twitch in anticipation of the recoil, it would suggest that their grip strength is weak, which means that they're not following the best practice.
Well, Mr. Stout, how could you determine whether or not Ms. Cantrell had flinched?
I determined this by considering two factors, the caliber of the firearm and the blood stain that resulted in the shot.
Now, we'll talk about the blood stain later. For now, can you explain what you mean by the caliber of the gun?
Yes, sir. The caliber of the Glock 22 is quite low. It's very typical to see non-experienced users find this firearm. Given the caliber of the Glock 22, it's very unlikely that the recoil causes it.
Does that have anything to do with why people flinch?
Yes, typically why people flinch is in anticipation of the recoil.
So what, in your review of the record, what did the evidence tell you about the cause of the second shot?
It told me that something other than user error probably would have caused the second shot. See, when examining the Glock 22, I found that it had a very light trigger. And what this means is that very little force is required to press it.
How could the trigger's lightness have caused the second shot?
Considering the risk of locking the trigger, any external factors would affect the control that could have caused the second shot.
What do you mean by other external factors?
Well, this can mean a number of different things. If he was around other people and they bumped into him, or did really anything that could have startled him, considering the lightness of the trigger would have caused them.
I have exhibits 2G and 2H. They've already been entered into evidence. Mr. Staub, if you could pick up a copy of exhibit 2G and 2H. Mr. Barrow, if you could display exhibit 2G and 2H for the jury. Let's start with exhibit 2H. Tell us about the bloodstain. What is it?
That's the bloodstain that resulted from the shot. It's Justice Carver's.
And exhibit 2G, actually, what are they?
Well, if you look at the top left, there's a key that matches Mr. Cantrell, Mr. Cargo, and Mr. Allred to color-coded X's on the floor. This represents where they claim to be standing.
Taking a look at these photos, was there anything or anyone that was close to Ms. Cantrell?
Yes, Mr. Cargo's almost immediately.
What can you tell us about the placement of Miss Cargo's blood?
It's nearly in the same position as Mr. Cantrell's eyes.
Is there any significance to that?
Yes, sir. I use this as a corroborating factor. My conclusion states this.
You can set those exhibits aside. Mr. Staub, what is your conclusion?
Sir, I concluded that an external factor, unrelated to Mrs. Cantrell's use of the firearm, caused the fire on May 28, 2022.
Thank you, Mr. Staub. No further questions.
Cross-examination.
Yes, John.
Good afternoon, Mr. Shaw. Good afternoon. I'd like to start by talking about your conclusions in this case. You don't blame my client, Justice Carlo, in any way for getting shot at the defendant's gun, do you?
It was possible that an external factor would have affected Mr. Cantrell's use of the firearm, and Mr. Cargo can be an external factor.
So your testimony that an action or a factor of my client may have caused the accidental shooting in this case?
I said an external factor, and Mr. Cargo bumping into Mr. Cantrell is under that list of external factors. It's a possibility.
It's your testimony that my client's bumping into Ms. Cantrell may have caused the accident?
Sorry, could you repeat that?
Yes, sir. So is it your testimony that Ms. Carbo's bumping into Mr. Cantrell was an explanation for this accident?
No, I said that it is a possible external factor.
Well, let's move on, Mr. Shaw. You actually blame the firearm itself for this incident.
Yes, I found that the firearm had an overly light trigger, which was a factor.
Simply, like you said, it's the overly sensitive trigger of the gun that you deem was the most likely pump.
Yes, that was one of the external factors that I listed.
Now, as a part of your record in this case, you read the sworn statement of Drew Cantrell, right?
Yes, I did.
So you're aware that Ms. Cantrell claims that the gun's recoil was more violent than any other recoil she's ever handled before.
Yes, she did say
That unexpectedly violent recoil caused the gun barrel to be redirected back and to the right.
yes, sir, but she eventually gained control of the firearm after it shifted to the right.
And back and to the right is when my client was told to stand. Right?
Yes, I believe that's what Mrs. Cantrell told us to understand.
So the unexpectedly violent recoil created a situation in which a loaded firearm was aimed at my client's leg. That's right.
No, it was not solely based on the recoil.
But however, the gun was aimed at my client's leg during the incident. That's right.
Yes, but that is not solely based on the recoil of the firearm.
The recoil is a part of that conclusion. That's right.
Yes, but it is not the sole factor.
The truth, Mr. Staub, is that Ms. Cantrell would have learned about the violent recoil had she simply followed Shooting Star's gun safety.
Objection. Question calls for speculation.
repeat my question, Shashank. It's true that Miss Cantrell would have learned about the violent recoil had she simply followed Shooting Star rules.
Can you expand on that, please?
Yes, sir. Let's talk about those rules. I believe you have a copy up there.
Yes, sir.
These rules are posted on the inside of Shooting Star, right?
Yes, I believe they are.
I'd like to turn your attention to rule number 7. Just read, please read silently as I read aloud. Check your weapon. Always make sure your weapon is functioning correctly, properly cleaned, and safe to use. Right?
Yes, that's correct.
And you'd agree that this rule goes to the mechanics of a firearm, right?
Yes, sir.
Because the functionality is dependent on the mechanisms within the firearm.
Yes, you're correct.
So you'd agree that it's important to assess whether or not the gun is functioning mechanically correctly.
Yes, of course.
Because every gun is different, right?
Yes, sir, that's correct.
Every gun reacts differently.
Yes.
Even the same gun with different ammunition could react differently.
Yes, that's correct.
Because if you fail to assess a firearm, unexpected things can occur.
Yes, you could say that.
Unexpected things like a harsh, violent recoil, right?
To an extent, yes.
Or things like a violent, or things like an overly sensitive trigger. That's right.
Yes, as I previously stated.
Now we can set that aside. From your work in the case, you read your Cantrell statement, right?
Yes, as you previously said.
Right, and from reading that statement, you're aware that Miss Cantrell took the brand new Glock 22 that my client had just purchased and took it directly to the range to teach the course, right?
Yes, I believe that's what it
So Miss Cantrell never test fired the Glock 22.
Not that I'm aware of.
She never assessed how the particular gun she was demonstrating was functioning.
Not that I'm aware of, no.
She certainly never assessed whether that gun was functioning safely or correctly, right?
Again, not that I'm aware of.
And so she never learned about the violent recoil until after my client was shot.
Right. Yes, while that is correct, regardless of the recoil, that was not the sole factor on why Justice Carter was shot.
Regardless, Ms. Cantrell never testified the gun.
Yes, that is correct.
She never learned about the violent recoil until after my client was shot. Yes or no?
Again, yes.
Thank you, Mr. Shaw. No further questions, Your Honor.
Can you redirect based on that?
No redirect, Your Honor.
I will give the judges a moment to enter their scores and have this give me a note.
One, two. 30. What's the second? Public perception. Mm. 42.
Okay, as per interim regulations, I understand the defense rests its case at this time. We will take no more than a 5-minute break before closing arguments, unless either side has an objection. Timekeepers, can you please set the clock for 5 minutes? Thank you.
Eight minutes and 42 seconds.
You're on time.
Your Honor, the plaintiff has 11 minutes and 30 seconds and the defense has 8 minutes and 42 seconds.
Okay, thank you. Are we doing a time for break?
1 minute left.
Is everybody back?
Not all our witnesses are back, Your Honor, but we're ready.
Plans ready to 12?
Yes, Your Honor, everybody's here.
All right, in this jurisdiction, the plaintiff presents his closing argument first. In fact, I don't know any jurisdiction where the plaintiff does not present a closing argument first in the prosecution, so. Counsel for Justice Carbo, how much, if any, time would you like to reserve for rebuttal?
Your Honor, may I reserve the remaining time I have for rebuttal?
Whatever time you have after your summation?
Yes, Your Honor.
Okay, yeah, you may do that. Okay. Plaintiff had over 11 minutes, is that right?
Yes.
Okay.
Yes, Your Honor.
A little over 8 minutes.
Yes, Your Honor.
Okay. All right, you may proceed.
Yes, Your Honor. And before beginning, may I ask that my timekeeper sit and witness stand so I can probably see the time?
It's not bad. Can you do that? Can you do the witness stand? Great.
Yes, Your Honor.
And Pedro,
You may.
may it please the court, opposing counsel, in members of this jury, the warning signs were all there. That's what Mr. Majel told you at the beginning of today's trial. And now we can see that he was correct. On May 28th, 2022, there were warning signs that Ms. Drew Cantrell was unfit to be a firearms safety instructor. Now, the jury also learned that Ms. Cantrell was hired because Mr. Coleman believed it was good on the check day. You learned that Ms. Cantrell was hired because of money. Look at the safety. In my client, Ms. Justice Harbaugh paid the fine. The jury asks the plaintiff to have the burden of proof. We must prove to you by a preponderance of the evidence that Ms. Drew Cantrell was unfit to be a firearms safety instructor. That Shooting Star Gun Club knew or should have known that she was unfit. And lastly, we have to prove that the hiring and retention of Ms. Drew Cantrell was a direct and proximate cause of Ms. Carter's injury. But members of the jury, I also want to remind you that you don't have to prove that Ms. Cantrell, Ms. Carter rather, had no role in this accident. Rather, we have to prove to you by a preponderance of the evidence that it was 51% more likely Cantrell's fault, or rather the fault of Shooting Star for retaining and hiring Ms. Cantrell. Throughout the trial, we piloted 3 facts, and all of which prove that we better learn. Fact number 1, Drew Cantrell was unfit to be a firearms safety instructor. Fact number 2, Shooting Star knew and should have known that Ms. Cantrell was unfit. In fact number 3, they still put a gun in the hands of Ms. Cantrell. But why? I'll take each of these facts one at a time, starting with the first one. That Ms. Cantrell was unfit to be a firearms safety instructor. It was the jury who learned today about a criminal record showing past instances where Ms. Cantrell violated the simplest safety rules, traffic laws. You also learned that in May of 2021, she violated the second rule of Shooting Star basic gun safety by aiming a firearm at another person in the shop. You also learned that after she became a firearm safety instructor, even after she received a certification from the state of Ontario, she committed another safety violation. She took a loaded gun out of the gun range and into the store field, violating the 5th rule of Shooting Star's gun safety. You also heard Dr. Judd say in the stand that in his professional expert opinion, Ms. Cantrell was unfit to be a firearm safety instructor. Members of the jury, don't let the defense counsel come up here and tell you that she was certified. Yes, members of the jury, she was certified. She wasn't qualified. And that's what Dr. Judd did. Brings me to fact number 2, that Shooting Star knew and should have known that Ms. Cantrell was unfit. Now, there were 2 things they knew, and there were 2 things that they should have. I'll start with the 2 things that they knew about. They knew that in May of 2021, Ms. Cantrell had aimed a firearm at another person in the shop. They also knew that in November of 2021, she had brought a loaded firearm out of the gun range and into the storefront. We know this because Skylar Coleman formally reprimanded Ms. Cantrell for both of those incidents. He formally wrote her up in a memorandum. She was aware that Ms. Cantrell violated basic gun safety rules that they strictly adhere to. But as you see at the bottom of Exhibit 8, she was neither removed from the facility, nor was she denied future shooting privilege. No, members of the jury, she was promoted and retained without any further training. Members of the jury, there are two things that Shooting Star didn't do, that they should have. We learned today that Shooting Star supposedly performed a background check. Members of the jury, that means that either they saw Ms. Cantrell's criminal record, a history of not following safety rules, and chose to ignore it prior to hiring, or they never performed that background check at all. And never saw Ms. Cantrell's history of violating safety. And that brings me to why. The third fact. Why did they still put a gun in the hands of Ms. Cantrell to teach my client that safety? That's the money they're going to do. Mr. Coleman's own words. It wasn't bad on the checkbook. What they didn't tell you was that someone had just left the role as a firearm safety instructor. Mr. Coleman needed someone to fill his spot. And when Mr. Cantrell arrived, showing enthusiasm, he was hired on the spot. You also learned, in regards to the financial decision was to hire Ms. Cantrell, Mr. Hernandez said on the stand that Mr. Coleman told him that their aim at Shooting Star Gun Club was to put a gun in the hands of every citizen in Imperial. It was all a financial decision to sell as many guns as they could and to train as many people as they could for business individually. Now, I want to address a couple things that I anticipate the defense counsel is going to bring up. But first, I want to address the dominant report. The jury, they say we missed the mark, but they're completely wrong. The defense completely missed the mark. They didn't realize the dominant was stacking up year by year, safety violation by safety violation. In 2014, reckless driving. 2016, hit and run. 2021 of May, pointing a gun at another person. November of 2021, bringing a gun that was loaded out of the shooting range and into the storefront. And then finally, May 28th of 2022, violating the seventh rule that we see on that list. Ms. Cantrell failed to check if her weapon was functioning correctly before just bringing my client out onto the shooting range. If Ms. Cantrell had tested that gun, then she would have known about the overly sensitive trigger that Mr. Staub testified to. She would have known about the harsh recoil that she experienced only after she had already fired the gun to my client by her side. If she had known that, Mr. Jury, gun wouldn't have fired twice. Her arm would never move to the right. My client would have never made contact with her. And none of this would happen. Dominoes, members of the jury stacked up one by one by one, until eventually they all fell under. And I hope you can see them. All of this was is why we ask you to find the defendant liable for negligent retention and hiring of Mr. Cantrell. The warning signs were all there. And they always were. The problem was that the defendant just didn't care. Thank you.
Defense?
Your Honor, I ask that my timekeeper be allowed to move the witness stand as well. Yes, will be allowed. Today, you have heard a lot about Ms. Cantrell. You have heard a lot about her history with fire. But today's case is about causation, not Cantrell. When you consider all the evidence, it becomes clear that the plaintiff could not draw a straight line between Drew Cantrell's retention and Mrs. Carbo's act. As a plaintiff, they held the burden of proof. They had to prove by preponderance of the evidence, meaning more likely than not, that it was Drew Cantrell's retention which was the proximate cause of Justice Carbo's injury. But they failed to meet that. The plaintiff's case missed the mark on proving causation. The plaintiff didn't follow instructions. Ms. Cantrell taught a safety rule. She explained the rules. She gave them eye and ear protection. She told them what to do, and she told them where to stand. After following proper procedure, she turned around to focus on safely demonstrating how to fire the gun. Now the plaintiff had gotten closer. She had moved from where she was told to stand. The plaintiff claimed she never moved. And remember, Mr. Barber's cross of the plaintiff, we gave her an opportunity to come clean. But she doubled down. She really wanted you to believe that remaining behind Mr. Cantrell, that she didn't just flinch or jump, but that she spun all the way around and shot. That's what has to happen if she remained behind Cantrell. So let's talk credibility. Just to be clear, the plaintiff and Ms. Cantrell are saying two completely different things. But the nice thing about this case is you don't have to take anyone on their word, because we showed you the physical evidence. We showed you the picture of the X's where everyone was standing. We showed you the picture which depicts where the blood stain. But now I want to make myself abundantly clear. Mr. Barra, if you could toggle between exhibits 2G and 2H. Just look. Now you can see where the blood was in relation to where Ms. Carbo claims to have been standing. Not only is it nowhere near that X, but it's practically on top of Mrs. Cantrell. How did that happen if the plaintiff never moved? When opposing counsel gets up here to talk to you in a minute, I want you to ask him how that happened. What other possible explanation is there? Their client's blood is in front of where she claims to have stood. The only way that makes sense is if the plaintiff. I want to bring you back to the cross of the plaintiff. Remember that Mr. Barra positioned himself in relation to the plaintiff in accordance with Exhibit 2G, in accordance with where the plaintiff placed Ms. Cantrell and herself at the time of the incident. Mr. Barra held his hands out as Ms. Cantrell did when firing the gun, and he asked the plaintiff if she could see what he was doing. She said no. Now remember, he positioned himself according to the plaintiff's story. If she couldn't see up here, then she definitely couldn't see when it happened on the ring. But that didn't stop the plaintiff from testifying at length about what she saw Mrs. Cantrell do before fire. So, was the plaintiff lying? Maybe she wasn't. Maybe she did see what happened because she moved. Because she had gotten closer to get a better look. Because the plaintiff bumped him, Mrs. Cantrell missed her shot. Mrs. Cantrell was spoken. She had given the instruction, and now it was time to detonate. She aims the gun and pulls the trigger. The plaintiff jumps at the sound of the shot and bumps into Mrs. Cantrell. Miss Cantrell loses control of the gun, it falls to the floor and falls. Whether it was an Olympic marksman on the range that day or Mrs. Cantrell, the accident still happened. No one would have accounted for something like this. And let me make myself clear. It is not our contention that the gun was in any way defective. It is not our contention that it was the recoil by itself which caused the incident. The truth is, the recoil would have been perfectly manageable for Mrs. Cantrell had it not been for the intervening causation. Had it not been for Miss Marbo bumping the arm of Miss Cantrell at the same time that she had fired it, at the same time that she was trying to manage that recoil. The plaintiff's case missed the mark on proving causation. They spent the whole trial exhausting the idea that Miss Cantrell was negligently retained by shooting. They went on and on and on about her past accidents and her history with guns. But members of the jury, that's not what they had to prove. This was a case of causation. They had to prove that the retention of Drew Cantrell directly caused the accident. The fact is, they couldn't draw a straight line between Miss Cantrell's past accident and the accidents in question. And we called an expert who told you just as much. That neither of the incidents happened in the rain. That neither of them happened during a safety instruction. That neither of them involved a discharge of the fire. And that neither of them resulted in injury. This was in no way foreseen. Nothing like it had ever happened before, and Shooting Star had no reason to believe that anything like it ever would. At the end of the day, this case isn't about it. It doesn't matter who was on the range. The cause was completely independent of the team. The cause had everything to do with the student, Justice Park. But the plaintiff didn't talk much about causation. They failed to show you how this accident happened. But we didn't. We showed you exactly. We showed you the physical evidence. And you cannot deny the fact. The fact that their client's blood is in front of where she claims to have been standing. The fact that if Miss Marble really did remain behind Miss Cantrell, that Mrs. Cantrell would have had to have spun completely around the shooting. And the fact that Shooting Star Gun Club is not fun. When you sit down and consider all the evidence, you'll find that we've proved our point well beyond more likely than that we've proved this to you absolutely and without a doubt. And we trust that you'll make the right decision. Find Shooting Star Gun Club live. Thank you.
Awesome. Okay, rebuttal argument.
Yes, Your Honor. May I ask how much time I have remaining?
2 minutes and 55 seconds, Your Honor.
Right, ladies and gentlemen, because the plaintiff has the burden of proof, the plaintiff gets a last word. So, you may minutes to rebuttal argument. So longer than 2 minutes and 55 seconds.
Yes, Your Honor. And may I also ask that opposing counsel share the demonstrative of exhibits 2G and 2H to the jury?
You want them to share it on the jurors' screens?
Yes, Your Honor.
Okay. Can you do that, counsel, please?
Yes, Your Honor, we can.
Has that appeared on your screen, Your Honor?
It hasn't appeared on my screen. I still have the scoring. Does it appear on the jurors' screens? Okay, yeah, I don't know that it appears on the judges' screens. I think it must appear on the jury screens for some reason. I just have my scoring sheets on here, so you may proceed.
Yes, Your Honor. members of the jury, the defense counsel came up here and he missed the mark yet again. I'll run through everything that I mentioned, starting with the blood on the ground. The jury, if you got shot in the leg and you fell to the ground, you can't fall into place. That's not how the human body works. You fall somewhere around you. It's reasonable to assume the blood's not going to be exactly where she was been. And secondly, Your Honor, they said that they positioned themselves for you to see, held out a gun, and then asked the witness if they could see what's going on. The witness didn't know how to respond and just said, no, you're standing in front of me. Two things in this picture. The X is clearly not directly behind Mr. Cantrell. And secondly, members of the jury, it's completely arbitrary. Opposing counsel purposely stood in the line of sight of my client, just so that she would say no, he wouldn't say. Jury, that's not evident. But regardless, they missed the mark because none of it matters. What matters is that I'll draw the straight line for you. The one that they said he never drew. All of the safety violations year after year led up to May 28th of 2022. And this Cantrell inevitably violated another safety rule and didn't test her weapon, which led to a recoil that moved her arms to the right before she made contact with his partner. If she had tested that gun, she would have been aware of that recoil, and none of this would have happened. Now, I also want to address something that they said about their expert, Mr. Staub. They told you that Mr. Staub said, and they make no claim in this case that it was the gun that resulted in this accident. Members of the jury, they're lying to your face. That's simply not true. Mr. Staub came up and told you the most likely cause of the accident was an overly sensitive trigger, which only draws the line in darkness, which tells you that if Miss Cantrell had fired that gun, not only would she have known about the harsh recoil, she also would have known about the overly sensitive trigger that Mr. Staub testified about. Clear, thank you, clear. Miss the mark. I'm defendant liable. Because all of the warning signs were there. For the defendant, could have killed us. Thank you.
Counsel, we thank you so much for your presentation today. The judge is going to take a few minutes to get through our ballots. If you need to stretch or use the bathroom, please feel free to do so. But just come right back because we're starting comments soon, okay?
Thank you.
We have to keep more stuff in there, but
I was not expecting this.
Like 20 seconds, but the Cowboys were like, I'm telling you, good one. Yeah. Good one.
go Bears.
Dude, this quarterback, I sure. Dude. Thing is, the Eagles. Lower their level. Dude, the team. That's where they do.
Are we allowed? We're not. Are we not? Oh, yeah.
Naeem.
You hit the wrong thing most. It's good that we practice.
Great, great work. Yeah. Great job. Yeah, you did so well. One shaker here, but kind of stealing my way, you know. I think the fourth off better. I mean, he kind of has like a pocket square. He like that's it. I mean, like the place of his crazy. I mean, he's got it on. Good job, good job. I can say you were a man. You did a good job. That's right. That's great. Who's gonna do Boston? I would both we did this. I just changed on the spot. Actually, yeah, I didn't make sure. Are you serious? Yeah, I just need something for me. No, you did. I don't think that's right. Yeah, I said right. You said lobster. I was like, are you telling me originally about this lobster? I know. Yeah, I was doing the same. My whole thing about Boston is so I just got out there and I went, yo, right. I don't know how we process that. My voice is like it's a stack. Cool pen. That makes sure it reflects. How was no pen? I made it.
I want like. What's on that? I want to take it. No, I probably would want, it was, I don't like it either. Was it, what's considered bad practice? It just sounds not good. It's like, bad practice gets out of your front grip without full control. Actually, it doesn't sound good. Or it's, one that's like, oh, it's on. Brennan's on. Yeah, he's right here. Hi, Brennan. Brennan. Not actually on the Zoom. Oh, there's no one in there anymore.
Oh, come on.
Stop touching, stop touching.
All right, since, no order. Gavel, or some, you know, but I'm gonna get a gavel thing out, I guess.